I have 10 minutes.
I imagine DOC will just search us and we can just go in whenever. I don't think there's any hold up.
All right. Well, my name is Donnie, sir. I'll be the bailiff for the court proceeding today.
Oh, nice to meet you. My name is Raphael.
Start going in.
Pleasure to meet you.
Just double check. Are they free to go in? Ah. What? Okay, line up. Hey there, Mr. Moss. Why you sitting way down here?
Oh, hey, Sonny. Sorry, I didn't see you there.
Yeah, it's okay. My outfit is very cute, just so you're annoying.
Congratulations.
On? The cute outfit? Thank you.
Yeah, did anything else good happen?
No, I don't think so. Oh, yes,
Oh.
I need to speak with you after this.
Okay.
I need to know your platform, what you are intending to do with the judiciary should you be the Chief Justice.
Montana, I'm sorry, okay? Please forgive me.
You shouldn't care that much about what another man thinks.
But I
about
love you.
What is wrong with this man?
No, you don't.
Here, I need to look at my phone.
You're denying my love.
2 minutes.
It's okay. It's okay. Okay.
Without
I'll
cigarettes,
live-
people
I'll live
start
another day.
professing their love to you.
Not romantically, like, you know, bromance, bromance, you know.
What? I didn't even touch you. No. Fucking chunky.
Vance, who's fat? I need to file that away so to insult them later.
Rick.
Okay. Thank you for that, Vance. I can't notice those things about people anymore.
Oh yeah, he's gained a lot of weight since your blindness.
Tip top shape, Your Honor.
Well, according to Vance, it sounds like you're going to topple over if anyone so much as breathes on you. It'll roll like a ball down the courthouse steps.
Sorry, Your Honor, but Vance lied to you.
I don't know. I feel like somebody would have more motive to be lying.
What the fuck?
Such as the person that put it on the weight. The fuck? Alright. Where are you going?
Hey, can you watch the crock pot tomorrow?
Sure. At what point in time? Mm-hmm. I guess.
It would be a bit more ideal if you gentlemen could move down just so the witnesses have space to be able to move around. Is that all right? It would be ideal, yeah.
No, no.
Oh.
Nathan, why are you back there? You scared?
Yes, 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 Mr. Missy, first trail. Solo BB. What is happy, huh? Time for the card. Yes, I don't know much about this. It will be affirmative defense. They have no one being around during that time. But then why the fuck did you offer? What? What? What is wrong with him? This got to be fun, exciting court. Mr. Defense Attorney, State Attorney, Prosecutor, can you hear me?
All rise. Court is now
Oh.
in session with the Honorable Magistrate Raphael Messi presiding.
Oh my god, you
You may
guys
be
wearing the
seated.
same jacket.
Are we?
Yeah.
I guess he has good taste.
Good evening, everyone. This court is
Th-
now in
what-
session. I am Raphael Messi, presiding
Is this
over
Raph's first
case
solo
2025
trial?
CM
Yes.
177, State of San Andreas versus Connor Westfield.
Yes, it
To
is.
knock out some quick rules of the courtroom, everyone is expected
Sonny, I've
to
gone a
remain
week without
polite and
smoking, and
respectful
every time
to
I
each
think
other
about
and
anything,
to the court.
it
Members
just
of the
turns
galleries,
into
please
like
keep
a
the
slow
noise
motion,
down
and
to a minimum and
I try
conduct
to
yourselves
imagine
with
like the
courtesy.
grass
Also,
swaying
if
in
you
a
haven't already,
beautiful
please
sunset, but it all
silence
just
your cell
turns to
phones.
gray and stops to
There'll be
nothing.
a zero tolerance for any
You know what
interference or
any of that
disruption
means?
during these proceedings, and anyone who violates these rules may be
Oh,
charged
why
then.
did you
without
quit
trial,
smoking?
contempt of court, and possible obstruction of justice.
Well, I got
Moving on to today's matter, could you please state your
I
name
got
for the
blood
record?
ritualed by someone.
Of
Then I
course,
got stabbed by that
pan
same
da ich yn
person
rhedeg,
about
my
40
name
minutes
is
after
Carwyn
that.
Llywelyn, uwcheralynydd y Wladwriaeth,
And
Senior
that
State
person, that
Prosecutor
woman, should
for
have been
the
arrested
Department of
from the
Justice
blood
at
ritual
Adran
thing,
Gyfiawnder,
and so
First Chair on behalf of the
I
state.
yelled at DOJ because of that.
Thank you. Defense. can
And
you
because
please
I
Oh.
yelled
say-
at DOJ, Raj yelled at me.
Yes, Your Honor.
And
Ernst
because
Schneider,
Raj yelled
first
at
chair
you,
for the
you
defense.
quit smoking?
I was trying to
Rachel Smith, second chair for
You
the
know,
defense.
put on a nice face. You know, try to turn a new leaf. Try something new. You know, wish
Connor
everyone have a
Westfield,
good
the
day.
accused.
You know, maybe the
Definitely
smoking had
do.
something to, but now I just feel empty. Sonny,
Quite
I feel
empty.
empty without my cigarettes.
You could try chocolate.
Before we do anything
Chocolate
else,
always help.
will the state please read
I-
the charges that Mr.
I can't be-
Westfield
I
is
can't-
facing?
That would be
Of course, Your Honor. The charges
terrible.
upon the indictment are as follows. One count of evading arrest, together with one count of unlawful possession of a Class 1 firearm.
Mr. Westfield, for the courts, how do you plead to those charges?
Not guilty.
All right, thank you.
Oh.
All right, before we move on to opening statements, are there any pretrial motions that need to be addressed?
Look at my cute
None
outfit.
from the state, Your Honor.
It's very cute. I just put together today.
Defense?
One moment, Your Honor. One moment.
Okay.
Oh, they might have pretrial motion.
So what the hell happened to you, Sonny, that I'm catching your case for it?
I feel like if I tell you, it could make you be unable to preside over the case.
You know what? Hey, you're right. That was a test. Just like I'm going to keep everyone on their toes as Chief Justice.
Oh, okay.
You asked about my platform or whatever.
Yes.
I don't have like a ton of written out like ideas of how to fix the judiciary in 10 days, just like that one movie about losing a guy.
Defense will
But
call a quick
basically, my
side by
pitch
your...
is this.
All right.
I am
Brief
going
sidebar.
to put the utmost and
Sidebar's so
unbelievable
far away from
faith
here,
in
though.
my department to use their knowledge, because I wouldn't want any judges to be doing anything if I didn't think they had the knowledge to make the decision they feel is correct. And if there's any blowback, I'm probably going to tell people to fuck themselves. I'm not going to be one of these like, oh, we need to, hey, Sonny, uh, your tone of voice was a little rude to that person that was clearly in the wrong. So technically, it's 2 wrongs now. No, I'm going to say, okay, who cares? But beyond that, obviously, I want to find ways to make things more efficient. Everyone's going to try and do that. I want to. It's that balance of efficiency for the courtroom versus still allowing for the complexity of cases to be kind of illustrated by whatever party, right?
Okay.
We could be the most efficient group of all time, but if murder cases are done in 3 days, but it's done shittily, then who cares if it's done in 3 days? It was done shittily. But like, realistically, Sonny, if we have a non-violent misdemeanor not guilty, which I know we don't have a ton of those, there's 0 reason why that shouldn't be tried within a week.
That is fair.
I think a lot of the procedures of the court could be reduced, but I'm sure Winnie's probably also on that.
These many procedures. I should know more of them.
There's a ton of things that are written out for the sake of so people can follow the rules, but also some of those are outdated and some of those only add more confusion.
I'm
But
trying to listen to the
Sonny,
court.
I feel like it boils down to this. If I win Chief Justice, I aim to, shine my values upon the judiciary, just as I'm sure Winnie would shine hers. And so it's up to you to choose if you would want someone of my constitution to deal with all the political nonsense at the top of the heap, or if you'd want someone like Winnie to do that. Have you voted already, by the way?
Yes, I am just asking for funsies. No, I did not vote
Oh.
yet. I like to be informed voter and make the educated decisions. I decide this based on the facts and the evidence.
Smart. That's a good way to do it.
Oh my god, thank you.
Truth be told, if you had asked me 2 months ago, I probably wouldn't have been ready for this or would have wanted it. But I think I'm in a place in my life where I've become comfortable with the limitations that my my has provided me out of nowhere. And I'm comfortable in my ability to
Deelgebouw Negenswedde, thank you very
process-
much, Your
oh,
Honor.
what the hell did
Your
you
Honor,
just say?
ladies and gentlemen of the gallery, dear learned colleagues,
What the hell was that?
today this is a matter, a rather
I don't know.
straightforward matter, simply
They are arguing
pertaining
the case.
to
I don't know.
the
They are
evading
doing
arrest
some
and unlawful
brutal
possession of a
binge.
Class 1
It didn't sound like English.
Plain and
so I don't
simply,
know
Your
if
Honor,
it
the only
sounded like-
Yeah, I don't know.
requirements that the prosecution need to prove for this offence to be successful is the operation of a motor vehicle, watercraft, or aircraft.
It's over. Who cares?
That's being element 1. Element 2 being fleeing from law enforcement or a Department of Corrections officer. And element 3 is attempting
No,
to
I don't-
arrest
I-
or detain them.
The long and the
Your
short
Honor,
of the
these
answer to
circumstances
your questions,
are
I don't
very
have
clear
some
for that offence, and I do
10-step
not
plan.
believe, practically
I
speaking,
have
that there is much
my
more to
set
say on that
of
point.
morals and
Furthermore,
values
the
and
second
my-
offence being the
Oh my
unlawful
God.
possession of a
constitution and
Class 1
character as a
firearm.
person.
Simple requirements there are
And if
simply
you
that
think
the
that is
firearm
something
was
that
unlawful
you're willing
to
to rally
possess
behind,
in these circumstances.
I'm
we
willing
will
to
do
punch
so
you in the face if you
through
don't stop
illustrating
talking.
that the firearm was not registered
We
to
can
the defendant,
discuss after.
and
I am
furthermore,
listening to the
that
court.
it would therefore be unlawful for him to have it in his possession. Your Honor, we will do this through a combination of eyewitness testimony together with documentary evidence, as we have indeed proceeded on the docket in advance. Your Honor, that's more or less, to cut it plain and simple, it's quite as short as that. This matter shouldn't really be too long, and I hope it is very, very good viewing for those in the gallery. Thank you very much, Your Honor.
Thank you. Thanks, whenever you're ready.
Of course, Your Honor. Your Honor, opposing counsel, people of the gallery, as we've outlined on the docket, we would argue today that this is a matter of wrong place, wrong time. My client, as we are mounting an affirmative defense, we will be pointing out that my client did not perform these actions of his own free will and was in fact under duress
affirmative
from the people
defense.
that jumped into his car, feeling threatened and doing his best effort to
do you know how many witnesses we have for
comply
this?
with law enforcement and
I
ensuring
have
that
not
the
a clue.
criminals in
I'm
this
not paying no
situation who
attention.
have
I
pled
not even
guilty
look
to
at
the
docket.
charges
I
are
gotta
in
tell you
fact
which one
caught
is
and
the docket.
reprimanded. We will show
perfect.
today
We're in the same
through
boat
the
then.
actions taken by my client as well as testimony from
Hopefully, Ernst called
officers
some
involved
witnesses to
that
prove
that he was not a
this
willing
arrest.
participant in the crime alleged and as such should not be found guilty of
Oh, I
evading
guess we will
arrest.
find out.
We would furthermore argue that should the evading arrest charge be invalidated and found not guilty here today, that the subsequent search of his car would also fall under, fruit of the poisonous tree and be invalidated as well. That's all, Your Honor.
All right, thank you. State, whenever you're ready. It's your case to me.
Thank you very much, Your Honor. Firstly, prosecuting counsel would like to call Senior Officer Layla Diaz 263 to the stand, please.
Lady Diaz.
Oh, that
Hello
one
there.
responded to my blood ritual thing.
Lady Diaz, you may approach.
Oh, that is interesting.
Yeah.
Would you
She
like
didn't
an
end
oath
up
or an
arresting
affirmation?
Junie Peters, who did it.
Affirmation.
Did you join the
All
cult?
right, if you would raise your hand for me,
No,
please.
Junie Peters made me do it against my will.
Do you solemnly
Ah.
affirm to tell the
And
truth,
then I told,
the
then
whole
she
truth,
called
and nothing
Diaz
but the truth?
and Madeline Monroe,
I do.
who she'd done this
You may
to
take your
previously.
position.
And then I reported it
Witness
as a
has
crime,
been sworn, Your Honor.
and then
Thank
nobody
you.
was arrested.
Your Honor, if I may approach the witness.
Oh, that's interesting.
Of course, just across the board, everybody's allowed to approach the witness.
Thank you
Apparently
very much for
DOJ said
standing
no,
order, Your Honor.
which is why the whole yelling thing happened.
Officer,
know
could
to
you
say
please
for
state
this.
your full
Yeah.
name, rank, and for the record, please?
Yeah, that always the first question.
It's Layla Diaz, Senior Officer. Was 263, now 416.
And how long have you been on the job?
Apologies for that. In my
okay.
error, I've completely mistook the emerging departments. Officer Diaz, what was your involvement in this matter?
Oh, never mind. Right to it.
So on the day in question, I was doubled up with now Corporal Lucas Evans. We responded to a rummaging call.
I know I am going to just
down
get up
in
and silently
the
move away
Vespucci
from
Beach
him and let him
area.
continue to talk to me.
On arrival, there was 4 suspects in total. 2 sat in a Hellhound vehicle, and 2 seen rummaging through vehicles on the sidewalk. Myself.
Your Honor. Apologies, if I may, Your Honor. Council would introduce herein Exhibit A, being a photograph of the relevant vehicle, the Hellhound in question, and then afterwards Exhibit B, which is the photograph of the secondary vehicle, and then afterwards Exhibit C,
Pull up
being
this
the photograph of the vehicle once more, as defined in Exhibit B.
All right, defense.
No objections, Your Honor.
All right, they have been admitted.
Yeah, so then we approached the rummagers, myself, Corporal Lucas Evans, and Officer Lawson Gray. We had a bit of a back and forth conversation with 2 of the suspects that were rummaging through the car. I
Oh
made
my
my
God.
made my way around to the front of the Hellhound to see who was inside. Took some photographs. They asked why I was taking their photo, but obviously I was just documenting the scene as it was, as is standard protocol. And then Lucas Evans
I got a new case
asked the
already.
suspects what they were doing, why the vehicle was waiting, and one of the suspects uttered, "Well, let's find out." And with that, the 2 suspects fled into the back of the Hellhound. They were told to stop, that they're not free to go, and then the Hellhound, driven by Connor Westfield, was evading at speed, at which point officers pursued.
And just to confirm, once again, you did you ask him to stop? You made this clear he was under detention?
Yes, we let the suspects know they were not free to go and that they needed to stop as they were getting into the vehicle. And they evaded along the beach, and the pursuit carried on up into the hills.
You know approximately how long this pursuit lasted?
Do you have the license, Cyrus, on in the
I'd
pursuit?
probably say no more than 10 minutes.
What were you wearing?
The car was then rendered inoperable up in the hills, where the two suspects that were in the back of the Hellhound that were seen rummaging through vehicles fled on foot. Corporal Lucas Evans pursued after one suspect on foot. I pursued the other, whilst Lawson Gray stayed with the vehicle. We managed to apprehend both suspects, took them back up to where the vehicle originally went out, and that's when myself and Officer Lawson Gray approached the vehicle and asked the driver and the front passenger to step out.
Did the suspect at any point stop willingly?
No.
Do you have any reason to believe that the defendant was not acting of his own free will?
No.
Thank you very much, officer. No further questions, Your Honor.
Thank you. Defense? You may cross.
One moment, Your Honor, just to confer with Coca.
Of course.
I think he is wanting the vote. I'm going to do a writing vote for Lady Clarkson. I'm eating my cup of noodles. It's very spicy.
Sonny, if you were a gun, what kind of gun would you be?
What kind of gun would I be? I would be the one that, probably the AP pistol, because it is little, concealable. It is kind of cute, and you can paint pink. And it is automatic. It is quick fire. It's a like me. I have quick fire.
That's the best answer I've gotten so far.
Oh, thank you. They put many thoughts into this.
Well, you aren't the first person I've asked, but still, it is the best answer.
Did you just say I am the only person, first person you asked this?
Yeah, I figured I'd try it out to see what you say, and if it's a good indication of how someone thinks, maybe I'll use it on other people.
And what is the purpose of this question?
One is to see how fast people think on their feet. Two is to see what people think of themselves.
All right, we're going to proceed.
Great.
Oh.
Defense, you may cross.
Hello, senior officer D.
Oh, oh God.
So you stated in direct questioning
Just going to put that down
that
there.
you told the suspects
Put that
getting
down
into
there.
the car to stop.
Whoopsie.
Did something happen?
Tell
Why'd you
the
say, "Oh, God"?
defendant to stop? Did you tell the
Oh,
driver
whoopsie.
that they are detained?
I almost dropped my pistol on the
The
floor.
time in which the suspects got into the car and the driver
wouldn't have been
started
good.
driving away
That wouldn't
was
have been
very
good at all.
quick.
You almost got shot by the bailiff.
The
probably.
order to
I don't know.
stop, they were not free to go, was a general order given to every single person in that vehicle.
So that's a no on my question then.
No, that's the direct order that was given to the suspects in the vehicle. There was 4 suspects on the scene, not just the 2 seen rummaging through vehicles. all 4 of them were told they were not free to go. At which point the suspect in question, Connor Westfield, had already began driving away.
So did you or did you not directly tell the driver to not leave the?
Objection, Your Honor. Asked and answered.
Good
Defense?
objection.
Your Honor, this question has not been answered. This was a simple yes or no question. She said no, he wasn't directly told because the timing was too low, and then said there was a broad question, so yes. So the defense wishes to clarify which one of the two it is.
Your Honor,
Was
Well,
apologies, Your Honor, if I may.
State.
Apologies. Your Honor, counsel would state that the witness has made it abundantly clear this was a general order to all persons on that vehicle, and therefore this question has more or less already been answered.
We'll allow one last rebuttal from the defense.
Your Honor, we would point out that the question was about a direct order given to the driver, not a general broad order in the sense of everyone on scene.
I believe that DS did, in fact, answer the question. So we're going to sustain that objection. Please move on.
I think that was well ruled.
Senior Officer Diaz, you mentioned that the chase took about 10 minutes, correct?
Yeah, I wouldn't say it lasted for any more than that. That's the vehicle pursuit, just for clarification.
Yeah, that's what I mean. Yes. During the pursuit, the driver repeatedly crashed into different objects, correct?
Objection, Your Honor.
Yes. Oh, my bad.
Autoscope.
Oh, actually, we withdraw our objection. No,
Sure,
no,
okay.
it's perfectly in order. Apologies, Your Honor.
Okay, you may continue.
If you wouldn't mind, please.
Yes. During the chase, the driver crashed into a lot of different things, correct?
Yes. Not uncommon.
In your professional opinion as a law enforcement and the experience you have made as that, what is the usual result if a suspect crashes into a lot of things during a chase?
The usual result of a suspect crashing into things during their attempting getting away is usually the vehicle goes out.
So, in your professional experience and opinion, if a suspect wishes to successfully evade police, they would need to crash into as little things as possible, correct?
Objection, Your Honor. Calls for conclusion.
Oh, good.
The defense.
What is happening?
Well, I am not asking about
this
her
is an
opinion. I'm
interesting
asking
objection.
about her in her professional
I think
experience.
Is he saying that his
I am
client
under the
crashed the car
assumption
on
that
purpose?
Senior Officer Diaz has had
That's part
Yeah, I
of
a
his
think so.
sufficient
affirmative
amount of
defense?
chases to, give a matter on them.
Your
I think
Honor,
that is what he tried to
I'm
insinuate.
not a
Your Honor,
shit
if I may?
driver.
Of course.
I was crashing on
Detective
purpose.
Diaz has not been called as an expert witness. She has been called as a eyewitness. The distinction is quite clear, and therefore we maintain our argument, our objection, apologies, for calls for conclusion.
We'll allow the defense one last rebuttal.
No further rebuttals, Your Honor. I think we've made our point perfectly clear. This standard practice to be asking law enforcement about experiences outside of the actual case itself to supplement and support the case.
Great. So for this objection, I'm actually going to. I'll see where you go. I'll overrule the objection.
Sorry, Your Honor, would you like me to answer that question?
Yes, please.
Sure. Would you be able to repeat it for me, please, Ernst?
Yes, of course. So, in your professional experience and opinion as law enforcement, if a suspect wishes to successfully evade law enforcement, they would have to crash into as little things as possible, correct?
Not necessarily. Pursuits 9 times out of 10 go one way or another. Whether or not a suspect crashes into things or doesn't crash into things. You know, a suspect can have one bad crash and their car can be rendered inoperable. A suspect can have one bad crash and they're too injured to continue their pursuit. So it's, you know, there's a lot of variables in that scenario. And not crashing into things doesn't necessarily mean they're getting away.
Oh my goodness.
One moment, and I need to collect myself after that.
Copy. Where are my $200, Peach?
So just to confirm here with the courts and with everyone present here, you're stating that crashes have no relevance on a chase?
I wouldn't say they have no relevance whatsoever. You know, crashing can affect us as law enforcement pursuing suspects just as much as it can affect the suspects. So I wouldn't say they have an overall bearing on whether or not a suspect is able to get away.
Okay, well, you mentioned you mentioned two examples of when a suspect would be more likely to get caught, which were both crashes. So, is it more
Yes, I think
likely
that
than
is their
not
defense.
that a
He is
suspect evades
crashing
if
on
they don't crash?
purpose. He is not a bad driver. Very good driver.
I'm not sure,
Crashing on purpose.
to be honest with you. I think
Because he was
that
under duress and therefore
I've been on many
not guilty.
pursuits in my experience
Yeah, I
where
think so.
suspects have had a fair few crashes and then the primary officer on the pursuit has lost eyes and we're unable to regain visual on them. You know, like I said, there's many variables that come into play during a pursuit of a suspect, and sometimes crashes can greatly affect a pursuit on either side, and other times they don't. It's hard for me to conclude one way or another with a definitive answer on that one, I'm afraid, Ernst.
Understood. All right. Let's move to the part where they had crashed out. Did the defendant bail from the car?
No. Once I returned to the vehicle, the defendant and the front passenger were still sat inside the vehicle.
And you and Officer Evans both left the scene, correct?
Correct. Myself chased after one suspect from the back of the vehicle, and Lucas chased after another suspect from the back of the vehicle, and I believe it was Officer Lawson Gray that was behind on scene.
Who arrested Mr. Westfield?
Myself. I placed him in cuffs.
Did he contest the arrest in any way?
He,
Yes,
I
like his
believe
confidence.
he, to the best of my recollection, stated something along the lines of, you know, why am I being arrested? And I simply said that he was evading law enforcement. And once we are back at the station and begin processing, we can go through more once we're in the cells.
Did he break cuffs
No.
Did he in any way resist arrest?
No. He did, however.
Your Honour, motion to strike on that on the basis of ambiguity. Would counsel specify when?
Sorry, did he? I can specify, Your Honor. That's not an
Yes,
issue.
please, thank you.
Yes. Did he resist arrest at all after you ordered him out of the car and you tried to place him into cuffs?
No.
One moment to confer with co-counsel if we have anything else.
Hmm. I see what he is doing. That is a slippery slope. Just because you are being compliant with the arrest does not mean that you did not commit a crime. Did he ever stay there on the scene? Oh my gosh, I'm so happy to see you. Thank you for saving me. I was so scared. I'm a scared person. There's a lot of attorneys here. Oh my god, I like his signatures. Rafael Messi on the docket. It says post image, free image hosting, upgrade to premium. Want to embed images in emails? Question mark. That is his signature. You should have Siri look at the docket for this proceeding and have Siri describe the signature of Mr. Messi.
We got one more question, Your Honor.
Right.
Hello again, Senior Officer Diaz.
Hello, Ernst.
As you are hopefully well aware, detainment requires the
I like the way she
reasonable
said,
Hey, you know
suspicion
the
Hello.
thing that just
of
got
a
assigned?
crime. What crime did
You
you
just got
suspect
assigned.
my defendant of having committed, being in the
A what?
process of committing over?
The thing you just got assigned is not a real thing.
Evading arrest.
What do you mean?
I
That's all,
did
Your
the
Honor.
arraignment on all of it the other day. Everything got taken care of the other day. I just didn't put. I had them put it on the docket
Alright,
for
state, you may
because it was a
cross.
whole no arraignment charge technically.
Oh, so that case is closed?
Yeah.
No,
that
it's
case is
alright.
closed.
Officer Diaz.
Oh, perfect.
Yes.
I just said I was going to put. The
I just wanted to
information in there, and I
confirm
just
one
haven't.
thing with you.
Maybe you should do that.
What was
I
your
should do that.
initial
Why
reasonable
should you do
suspicion
that? So that I don't have to
for
be
detaining the
presiding
suspects on the
over it.
scene?
Right. Well, there's nothing to preside over.
The initial reasonable suspicion
They all
was
served,
that
like, 1,700 months in
himself,
jail.
his vehicle, and co-parts, if that's the correct term, were seen fleeing the scene, evading the scene of a rummaging call. We had our lights and sirens on whilst pursuing the suspect. At no point did he pull over. Therefore, we had enough probable cause that he was evading arrest. That was the initial circumstances under detaining him.
One moment, Your Honor, if I may have a moment just to gather my thoughts here.
Of course.
Mm, I love card.
So when you arrived on scene, there was a CAD alert. What was this CAD alert for?
It was a cuddler in. You're gonna have to forgive me. I can't recall its exact wording at this moment in time, but it was regarding rummaging.
That's perfect. And was the defendant in the locality of this call?
Yes, right beside it.
Thank you very much, Your Honor. No further questions.
defense?
Not of that. You know, we have one for previous direct.
No, you should have asked
We
it.
would obviously be able to call it in direct questioning, but I think for the benefit of everyone and for, Officer, we would then afterwards have nothing for direct questioning for Officer Diaz. So I believe if opposing counsel and Your Honor would be agreeable, we have one thing about the final question counsel prosecution asked in the first in regards to the question of if he was acting on his own free will.
Second. State, do you have an issue with that?
Yes, Your Honor. It's bizarre that we moved the circumstances that now the defense is introducing evidence halfway through a prosecution case, Your Honor.
Do you agree with the state? It's a little bit bizarre. Or you have the ability to recall Diaz on direct. We'll just go ahead and
Sounds good, Your Honor. We're unsure and confused on what evidence we're planning to introduce. But we'll recall the witness on direct. That's fine, but
further questions. Now, do you have any?
yeah, no further questions. Otherwise, Your Honor.
Okay, make sure. You are free to leave the bench. Please don't go anywhere if you're still under subpoena, as you will be called on direct.
No problem, Your Honor.
State, call your next witness or piece of evidence.
Thank you very much, Your Honor. Counsel would call Officer Lawson Gray. We're going to omit the badge number as they have changed. I do not want to embarrass myself once again before the court, Your Honor.
Would you like an oath or an affirmation?
No.
Oh.
All right, go ahead and raise your hand for me,
Who
please.
is this? Losing Gray?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You may take your position. Witness has been sworn, Your Honor.
All right, thank you, State.
Thank you very much, Your Honor. Officer, could you state your name, rank for the record, please?
For sure. It's Officer Lawson Gray with the San Andreas State Police.
Thank you very much, Officer Gray. Now, Officer Gray, were you attached to the incident why we are for the incident pertaining to why we are in court today?
I was, yeah. I attached.
There you go. It's an actual word. Look at me on train number 4. I usually get on the last one.
Corporal Evans did.
Kelly will get it on the first, no
And
matter.
what was your involvement to this matter?
Arrived as an additional backup unit, and arrived on scene to provide security in case there was any suspects that fled from the scene while they were interacting with the suspects on scene.
Please outline what happened at the incident, please.
Sure. So, I attached onto the catalyst for the imaging call. I arrived on scene. I saw Diaz Evans talking to 2 suspects that were around 2 vehicles that had their hoods and trunks open.
Sorry if you got your hopes up over that
black and colored
prison
SUV
break
there.
case.
It appeared to be 2 times occupied.
When did
it
this
was parked in
arrangement
a
and
way that would kind of
CTC
lead
be
me to
occurring?
believe that it might be a
5 days
vehicle
ago.
used to get away if it should come to that. So at that point, I noted down the plate and flagged it, and then communicated that to the officers on scene.
Something. And did you attach to the pursuit?
I did. I took primary off the initial pursuit when the vehicle fled.
I think I said something in
Outstanding.
our
You
emails
described
about
the end of the pursuit
not to
for me,
worry
please.
about it.
For sure.
'cause I was gonna
the vehicle went up into the hills. I can't remember the exact
write the
address.
ruling the day of or
road
the
that
day
we were
after, and
on
I
at the
just
time,
didn't.
But they crashed out. At which point, 2 suspects got out from the rear seats and fled, which Diaz and Evans.
This is not very
followed
good reflection for potential
separately
chief
between the 2.
justice.
I stayed up top with the vehicle as 2 suspects were still inside the vehicle at the time.
Would you like me to
Um,
count how many of the
well,
last 30
additionals were
warrants have been
rolling
done
up to
by me?
support the two officers that were in the foot pursuit.
No, thank you.
Did you effect a search on
Sure.
the vehicle?
If you need me
Once
to
the
prove that I'm
two-
doing my
we got the
job,
two
Sonny,
suspects
I'm
out of the
more than happy
vehicle,
to.
after the other suspects were detained,
No, that is okay.
Okay.
I went ahead and performed the search on the vehicle.
Do you believe me?
And what was found
yes,
in the
I
vehicle
believe you,
which drew
Sandy.
your attention?
Okay.
While I was documenting the vehicle, I went ahead and
Try to be
got a receipt,
snarky, it
popped open the
backfire.
glove box, and to which
I do need to do
found
better on the
a
warrants.
firearm. I went ahead and took that in my possession and then ran the
Yeah, am I
serial number
missing
on
something,
it,
or is there
and it did
been
not come back
nothing
to
notable
registered
that has
owner
happened in this
for
case
anyone
so
we had
far?
in custody.
No, I don't
Your
think you're
Honor,
missing
counsel
anything.
would introduce exhibits marked
Other than the
15,
bad driving means
being a
not
photograph of the contents of
evading
the glove
arrest.
box. Exhibit E being a photograph of the endurance pistol
Your
shown
Honor, I
in
wasn't
Exhibit
trying to
D,
evade. I couldn't stop hitting
clearly
these
displaying the
poles.
serial number. Exhibit
Mhm.
F, all legally owned firearms owned by the defendants as of the 4th of October 2025. And Exhibit G, an MDT note, which we have redacted from public viewing. We do not wish to describe in order to protect the content of that note, which is quite self-explanatory. Furthermore, finally, Exhibit H. Yes, Exhibit H, which is a close-up of the firearm shown in Exhibit D.
Right, getting all that pulled up. Okay, defense.
What is that sound always in his background? It sounds like he's
No
always
objection,
drying his hair.
Right, they have been admitted.
Standing, thank you very much. Which units were on scene for the crash in question?
That would have been myself and Diaz and Evans.
Standing. Your Honor, counsel would finally introduce Exhibit I, being the sworn affidavit authored by Corporal Lucas Evans.
Great defense.
Oh,
Also no objection.
thank you, lady. Yes.
Been admitted.
Every time I go to do
Standing,
that
thank you very
from
much, Your Honor. And finally,
OBS,
Officer
it
Gray, did you have
messes
any
it up.
reason to believe that the defendant was not acting of his own free will?
Objection, Your Honor. Calls for speculation.
Your Honor, I am essentially. Yes, Your
These
Honor, I am
old ass
essentially
computers
asking
about to
whether
explode.
whether the witness witnessed any, or whether the defendant exhibited any kind of mannerisms which would suggest that he was under duress or was not acting of his own free will. It's quite a straightforward question, and one which would not fall under the scope of calls for speculation, Your Honor.
All right, thank you. Just gonna go ahead and overrule the objection. You may answer that question.
Would you like me to ask the question again, officer?
Yes, please.
Not a problem. Did you have any reason to believe that the defendant was not acting of his own free will?
It's on the desk. Put it under the desk. Put it in a
No,
different
I
room,
believe
bro.
he was acting his own free will at that time, with regards to the vehicle
I
being
recognize
running and its positioning, everything like that.
that you cannot do
as,
that. That's not a safe
how
place
I
for
would
that
have
shit. That
interpreted
shit's
that
going
with
to
my
burn
professional
up.
experience
You
as
set
officer.
his desk on fire.
Outstanding. Thank you so very much, Officer Gray. Your Honor, no further questions.
All right. Thank you. Defense. Cross whenever you're ready.
Yeah, one moment again. You.
Of course.
I like how we always take a moment. I have to get up early tomorrow. Let me see this.
All right, ready, Your Honor.
Right, of course.
Hello again. How's it going?
Doing well. How about yourself?
Pretty good, pretty good. A bit tired, but you know how it is. So in regards to the direct questioning by the state, you are asserting that the grounds you raise for him, the defendant acting of his own free will, is the proximity to the scene. Is that correct?
Yes, with the way the vehicle was parked and how close the proximity to was to the cat alert, as well as to the scene where we ran into the two individuals that were appeared to be rummaging at the time.
One moment, Your Honor, I believe that's everything, but just gonna make sure. We have one final question.
All right.
Hello again. Just to clarify with the courts, you remained on scene with the other two suspects that were in the car the entire time, correct?
To the best of my knowledge, yes.
That is now everything, Your Honor.
All right. State, do you have any redirect?
None, Your Honor. Thank you very much.
Okay, defense, do you wish to recall this witness? The party, I guess.
One moment.
Sonny, how many warrants do you think you've done all time in your time?
I don't know.
Oh, well, okay.
Some.
No, I'm not goddamn accusing. I'm
We're
just
not going to be
curious.
recalling this witness, Your Honor.
I probably could do more, yes.
All right, state. Do
I
you have
also
any
wasn't
reason to
implying that.
recall this witness?
No, Your Honor.
All right, thank you. You are free to go. Release.
I feel like when we, you know how we are with warrants. I feel like we need something to address that.
All right, state. Please call your next witness
That
or
is
submit
fair.
the next piece of evidence.
Your Honor, that does conclude the state's case in chief. Thank you very much. We do rest.
All right. Defense, it is now your case to make.
Yes, Your Honor. One moment again. We'll be.
All right.
I'm spitballing here. This isn't something I'm like dead set on. It's an idea for that warrant issue, and it's probably going to make you want to vote for me less. What have you thought if we had a essentially a quota for the judges, just something small, 2 warrants a month or something like that?
I think that is not unreasonable.
If there's like a significant LOA, then obviously you deal with those as they come. But 2 warrants a month, I feel like that's not bad, and I feel like it takes some of the burden off of the people that do them more, and the people that want to do them more can still do them more. Because I don't think we're going to be in a place where people are fighting over which warrants.
I'm going to fight the people for the warrants. This is not true.
Defense would like to.
What would the defense like to?
I
Sorry,
don't know.
defense would like to recall Layla Diaz to the stand.
Oh, look at that.
Lydia's.
Oh, nice.
Oh yeah, some guy gave me a poem in Legion Square the other day. You want
Permission
to
to
see it?
approach, Your Honor.
Of course.
He read it to me before he gave it to me.
Hello again, Senior Officer D.
Hello.
Here, take a
So,
look at that. Sounded pretty good when he read it to me.
On what basis, on what grounds are you asserting that the defendant did not act of their own free will?
Similar
Or
What
did
is
to
act
this?
of their own free will?
similar to that
It's
that's
a poem,
already
isn't it?
been
The guy said it was
Oh,
a poem.
yes.
he was
Why
on
is he
scene,
writing you a poem about his
at the
father?
initial rummaging
I don't
call,
know. Maybe
very
he's
close
artistic.
proximity.
I don't know. He just wants to. He just wants
You
to be
know,
a
we
writer.
see those
Maybe
type
he's
of
just like
scenarios
trying it
very
on
regularly
strangers to
where
see
we
what
have,
clicks.
you know, the
Oh,
escape vehicle, so to speak.
it's very,
on
very
scene of
unique
crimes like
poem.
that. We had reasonable belief that he was the
It's good
getaway
to have it
driver.
back.
Should police arrive,
Thank you.
um,
I might put it on my
and
fridge.
that followed suit in the fact that once the suspects got into the back of his car, he drove away.
Oh, that is perfect.
A reasonable belief based on what?
Based on the fact that if he was there, if he wasn't there to be a getaway driver, for one, he had ample of opportunity before the suspects got into the back of
Oh,
his car
this is a
to
bad
make
question.
such claims stated. I did approach the vehicle. He had opportunity to speak to me if he so chose to. But that was you know, a standard call in my experience. We arrive on a scene of a crime and there's somebody there ready to attempt to get away.
Oh my god, I just want to know how much this shit is. What is your rate?
Though just for the benefit of the courts and also for our notes here, it was the proximity to the scene as well as the act of not stating that they were uninvolved that gave you the reasonable belief that he was involved.
Why,
Yeah, and
ask
the
and answer.
active evading of law enforcement after the fact.
Mm.
Yeah, all he did there was ask the question again to try and get something
Understood.
that
One moment, Your
sounds better for him.
No further questions, Your Honor.
State, do you have any cross?
We do, Your Honor. Officer Diaz, did the defendant make it known to you that they were under duress?
No, they did not.
And I'm presuming they didn't do that in the cells neither?
No, as soon as we arrived at the station, he asked for a lawyer.
And I assume he didn't do that during the course of the arrest itself.
No.
Finally, did counsel bring this up to you at all during the cell representation?
There wasn't any cell representation at the time.
In that case, that answers that then. No further questions, Your Honor.
I think that just
Alright,
ended the
defense,
court
yeah,
case.
Redirect.
Those were 3 questions that I think just ended this whole thing.
Yeah,
No,
that
Your Honor.
was. Yeah, that is the expected responding from him.
Right then.
Because it's a hey,
yes,
it's a
you
very
are.
good point. If you were under duress
go.
and being arrested,
Thank you.
could you make it known at any point? You ready for this guy to get on the stand and lie?
All right, defense.
Oh,
you may
please.
Call your next witness or present your next piece of evidence.
Yes, Your Honor. Defense would like to call the defendant, Connor Westfield, to the stand. Hang on, actually,
I love court.
one moment, second, Your Honor.
I love
Disregard.
court.
Apologies.
Sonny, do you want a girl dinner?
You want a girl dinner? Yes.
I figure we have to, have some fine dining for a defendant taking the stand.
Where did you get the girl dinner?
I got dragged some food truck thing, and we went to every food truck, and I had every part of my group read the menu and order something for me. I think the girl dinner was ordered by the clerk, Nicole Boss.
Oh, today I eat the city's spiciest burger. Oh my god. It was very
What did that on
spicy.
it?
Oh, they had the Ripper peppers. We call this screaming Ripper burger.
Oh my god.
Apologies, Your Honor. Yes, we will be calling the defendant, Connor Westfield, to the stand.
Oh, they're calling defendant. Interesting.
He's going to lie, and it's going to be
Westfield,
funny.
You are aware that you will be waiving your rights.
Yes.
Why is Raph still sound hesitant?
Right away. You're good. All right.
May I approach?
I think they're just making sure that
course.
he inform it. Oh my god, this outfit is so cute. I'm so proud of the work that I did to put together.
Would you like an oath or an affirmation?
While they're getting this sorted, Sonny,
All
are
right,
you
go ahead
taking
and raise
me
your hand for me,
seriously
please.
as a candidate for Chief Justice? I asked this for a reason.
I think everybody's serious.
Okay.
Do you swear to tell the truth, the whole truth?
That is why
and
I
nothing
asked
but the
you
truth,
about
so
your
help you God?
platform to make the informed
I do.
decision.
You may take a seat. Witness has been sworn, Your Honor.
Thank
Would you
very
like
much.
time to prepare something
Defense,
more
are you ready?
formal, or are you satisfied with
course,
your
Your Honor.
responding?
I'm satisfied. You said you had more questions after this.
Hello,
I mean,
Mr.
I'll be
Westfield.
straightforward
Would
with
you
you
be so kind as
with
to
whatever
state your
questions
name
you
for
got.
the record?
Okay, perfect.
Yes, my name is Connor
I
Westfield.
don't have more question. I just
And if I
wanted
don't
to
have
not
an
talk
answer, I'll
it
tell
about.
you I don't have an answer.
Mr. Westfield, why were you on scene on that fateful day?
I was just out for a drive
Objection
with my new
narrative.
friend Zoe.
Out for a drive. I was just out for a
Just for the
drive.
benefit of the court, Zoe was the passenger
Oh
of
my
the
god.
car.
Oh my
Yes.
god, this is about to be wonderful. He's about to perjure. He's going to get perjury.
Well, here is my
During
question.
your
If he is being
part
under
on
the
the
duress,
scene,
and the two
were you
suspects
ever
rummaging, not
directly
in the
told that
car,
you were being detained?
you just sitting there in the car
No.
and wait
When
for them to
officers
get into
arrived
the
on
car and
scene,
then drive
they
away.
came,
And
took
what?
a picture of my car.
How is he
I
under
started
duress?
taking a picture.
He could have driven away before they come
They
to the
said
car.
something akin to it being like what they do for that stuff, and then not once was I ever ordered to vacate the area or turn off the vehicle.
Wait, now he's arguing what the police were doing?
During the
Yeah, apparently.
scene, two people
They did
got
not
into
tell
your
him
car.
by
Did
name
you know these two
specifically. He
people?
is not free to go.
No,
Your Honor, I did it under duress, but also
no, I didn't.
I didn't know what I
It
was
was some
doing.
people that were on the side of the road.
What the hell?
When they jumped into your vehicle, what did they do?
They said to drive.
Did you feel you had to comply with what they said?
I
If he
couldn't
doesn't
see
ask why.
if they had anything in their hands, so
He
I
couldn't
felt like
see?
the best decision for the safety of myself and my passenger was to comply with their request to drive.
Oh my god.
Oh my god. He's
Oh my
correct.
I don't know. They just got in my car. I just had to drive.
Yeah, that is usually what I do when somebody does get
During
into my
the,
car. How about you say get the fuck out?
you know, during the complying, you did. Why did you
Yeah,
run
they
into
whip
them?
him. Why he not pointed at them?
Part of it was
If
a
the
mixture
state,
of I'm a bad
if the state
driver, and
has
part of it
any
was a mixture of the more shit I
has any
hit,
balls,
the
they'll ask him
sooner
if it's a
my
taxi driver.
my engine might stall out, and
Ah,
then at that point, it's them bailing from the vehicle.
So you're saying you intentionally hit things so the chase would be shorter?
What the?
Yes.
What was your reasoning to keep the chase as short as possible?
I wasn't involved in this incident. If I was involved in this incident,
if
I
he
would
was
have owned up
scared
to
of them
my
having
5
the weapons, you don't think they would be upset if he is intentionally crushing into things with him in the car?
After
don't think they would be
crashed
like,
out,
drive
why
better?
did you not bail out of the car?
Like I
What the
said, I
fuck?
wasn't involved. They said drive, I drove. Then
This is the worst
I
excuse I've
stayed
ever
on
seen.
scene, and then the two
Yeah, I am not
officers in
fan
the
of
car
this
right behind us
defense.
stopped, took
If
off
I was
after the two
judge, this is
people who
the
ran, and then
walk out, walk back in
the other cop
immediately.
came, left, came back,
Deferring
I think
period.
left again, and then that's when
Why was this not a?
Senior
This
Officer
this is a
Diaz
bench
came back
trial.
and ordered me out of the vehicle. And I complied with all orders.
I've been no
I
judiciary
had plenty of
available at the
opportunity
time.
to leave and get away.
So from your recollection, there was a
I'm
period
always
of time
available,
where you were
mostly,
not attended
sometimes.
to.
Yep, I could have gotten out of my vehicle and just walked away.
Wait, what? Wait, what was the question you just said that to?
I have no idea.
Did you in any way communicate with the officers that you were under duress?
When they told me that they were arresting me and they put me in cuffs, I had asked, "Hey, why am I being arrested?" They said that they'd explain more at the station. I told them
Why would you not say, "Oh my God,
that was about it.
I was so scared at that time. Thank
when I
you. I'm
realized
so
that they were
happy to
gonna
see you saving me."
charge me as an accomplice and
Wha-
stuff,
Hold on.
or as
Hold on.
evading and whatnot, I decided the best course was to just wait and ask for a lawyer.
I
One moment to
didn't
confer, Your Honor.
know I didn't know what to do. I just said they told me to drive and I drove. And then when the police told me what was going on, I just simply didn't say anything. What the hell is that?
I just feel down.
Sonny, this is making me really test my sobriety. I might rip a cigarette.
I have a cigar.
Hand it over, please. Thank you.
I am a nipple.
God, that feels nice.
Oh, you are welcome.
Oh, thank you, thank you, thank you, thank you, thank you, thank God.
Mr. Westfield, one final question to round this all up. Were you a willing participant in this matter and the getaway driver for this crime?
No.
I'm
No
so
further
excited for
questions, Your
Cross. I'm so excited for Cross.
Oh, nice. I did hear you.
All right,
I
State,
watched
you may
Lady
cross.
Clarkson's stream the
May I
other
have
day.
one moment, Your Honor,
course.
just to prepare my line of questioning?
Of course.
This would be my favorite time in court.
Mr. Westfield, you were told to stop by law enforcement, were you not?
At what point?
When the
at any
individuals
point.
got into your vehicle.
I believe they did say something akin to that.
So that's yes. To that effect.
To that effect, yes.
Did the two individuals behind you apply any kind of force?
Like I said in the questioning from
Yes or no,
defense,
Mr. Westfield?
I could not tell, as I do not have eyes in the back of my head.
You can't
Okay.
turn around?
Were
I could
you-
not
do-
see if they had
that's
any
Do you
weapons.
not have the rearview mirror? Can you not
That's
turn
I'm asking
around?
you if they hit you. If they applied any kind of contact, were you battered in any way?
No.
You were not. Outstanding.
He should have started actually lying.
Did you at any
a while
stage
ago. This
inform
is
law
just terrible
enforcement
lying.
that you were being coerced?
After I was put in cuffs, I did inform law enforcement that I was told to drive.
That's not what I'm asking. I'm asking that you were coerced. There is a difference here.
Coercion
Did
can
you
take
say
many
there was an
forms.
application of force?
Words can
Oh,
be
he
an
is being
application of
very
force.
angry. I like
this is
this.
hostile. I
Saying
like
Did
this.
drive
you
with the
state?
implication.
Did you state that you believed you were under duress?
I was unaware that I needed to state that as per just
You did not.
saying
Thank
I
you
did
very
not
much,
want...
Mr. Westfield. Mr. Westfield, do you know what Miranda rights are?
Yes.
And were you read them at any stage?
Yes. After they put me in cuffs.
Outstanding. Thank you very much, Mr. Westfield. Your Honor, no further question.
All right, simple to the point. I would have kept stabbing.
Yeah, I would have
but
asked a lot more.
I
Just
would
for
have kept
funsies.
stabbing.
Defense, do you have any redirect?
We think alike on a lot of court things. We really do.
Yeah, one moment.
I want a witness to feel pain.
Do you think they prove enough for the frivolous defense?
I don't,
Hello again, Mr. West.
maybe
Yes,
not
that
really.
is what I told him
I'm
in
not really excited
Joker's
to hear what
Kelly.
this is.
The two individuals jumped into your car. Did you have the genuine belief that there was an active threat of violence against you if you did not comply?
I just believed it. I
Yeah,
didn't know what was
I've
happening,
lived
but I
in this
believed
state
it.
long enough to
No, I
believe
assumed it.
such things are possible.
I mean, anything is possible.
Nothing
I am
else, Your
under
Honor.
duress right now. I believe that there is a meteor come to the country. I am under duress. I am going to go rob the bank so that
Oh
I
my
can get
God.
the money
Oh
to
my
build the
God.
bunker. I was under duress,
No
Your
further
Honor.
questions, Your Honor. Thank you very much.
I'm blind. Listen, I'm blind. I could think there's someone pointing a gun at me at any time. I'm under duress.
Right, Westfield, you are free to return to your
Exactly.
seat.
Oh, that is good defense. Maybe you should not have a gun.
I don't. I got robbed a while ago.
You didn't purchase no one?
No. People are hesitant to drive a blind man to a gun store.
Defense, perhaps any other piece of evidence or witnesses to call?
I don't know why. We can go there after.
Yeah, that might be good.
Oh my god. What if I am in the car driving Mr. Moss to the gun store and
Defense
Mr.
West, Your Honor.
Hades
All
comes
right.
to find me again?
Let me guess.
Alright.
10 minutes for closings for some
You
reason.
both. Does either party need any time
And
for
then Mr.
closing
Hades
statement?
shooting at
Stage is
me
prepared to
and
proceed, Your Honor.
not presenting
Love
to
that.
the
Defense
jury,
Defense
Mr.
would ask for 10
Moss.
minutes, Your Honor.
God damn it.
We'll
Uh-huh.
allow the 10 minutes. We'll meet back up here at
I will compromise. You can have
7:40.
6.5.
Your Honor, if we may.
Oh.
Counsel would like to inquire as to whether the defense have indeed invoked their affirmative defense.
Oh. Ooh.
That not that necessarily they met their burden, but that they have invoked it. That they can indeed intend to proceed with this matter.
That's
Your Honor, we did invoke it on the docket, and we also did specify, as it was ordered, as to what grounds of affirmative defense we will be called.
Council have no issue with that, Your Honor. We merely wished for it to be confirmed. Thank you very much.
Thank you.
That's I love a little snide. Your Honor, can we just confirm this thing? Can we confirm
We
that
have a
they're
little
fucked
bit more
over?
time. We'll say
Uh-huh.
He's gonna
7:25 is when we'll
25.
Oh
be
my
back. The
goodness.
court is now on recess.
Well, 14 minutes.
Thank you very
25
much, Your Honor.
after. God damn it.
Oh. Oh my god,
Is
that
there-
would have
is-
been so much fun to
You got a
question
funny
him.
accent. Where are you from?
Is there someone interesting we can call over and make fun of?
The fat man. The policia. There's a man in a spotty brown suit. There's a man in the back row in a gray suit with a red tie. I don't know who that is being. And there is
Who's in-
the
who's
state
in the leopard?
attorney, Loider. I don't, Mr. Constantine. I think something like that. I think. Oh, he see me eating the spicy burger. And I think he bring me the milk.
I can get him to give you some food and watch this. Vance, are you still in here?
Yeah.
Do you have spare food?
You like baby back ribs?
Oh my god, that sounds
Yeah, yeah, get over
delicious.
here.
Ask him, do he have some chocolate?
Do you have chocolate as well?
No,
They're
no
both for
chocolate.
Sunny.
I actually have no need for food.
Don't
I'm not-
shoot.
Why are you throwing your hand?
Why would you say don't shoot?
I don't know. You never know.
Did you see me pull out the gun in the middle of the court proceeding?
No, no, Bright
that
Star,
is
relax.
good.
You pulled out a gun?
Should know if the
Yeah,
bailiff
I
was gonna,
almost
you know-
dropped it. I put it firmly into the pocket.
The milk was
almost-
good, huh? Thank you for the
Oh, yes.
ribs.
Those are Sunny's ribs.
Oh, yeah, sure they are.
Oh, thank you.
So what do you make of this whole thing, Vance?
I think he did that shit, and he probably didn't. I think there's a way to argue that it just didn't. You didn't meet the burden.
I think he should have perjured if he wanted any chance of winning.
I lied.
I think he like white lied.
Yeah, go all
and
in.
If you're gonna do this, you got to go all in.
I think that might have been all in. I don't think there.
That was not all in.
I don't think he knew whether or not either of the other defendants had any weapons document on their person. Because that would
They
look
get
very
caught? I don't
bad
even
if
know
he
if they did.
say, no, they definitely had to. How the fuck do you not have the rear view mirror? How the fuck you just presuming to be under the duress
Well,
because you can't see or know what they are having? Did they
I-
say anything
in
to
my
cause the
defense-
duress?
my defense of it is if this is to be the case, right? If two random people climb into my car and say drive after cops show up, I'm like, all right, man.
You could just get out of the car.
Yeah, and then you
You
get
could
shot.
get out of the car. You could point the gun
With
at them
what
and
gun?
say, you can get out of this fucking car,
Well, they
not
could
the
have
taxi
guns, we don't
cab.
know.
I mean, you could look there.
Also,
Or
Vance,
usually,
I would
go
start
ahead.
driving, but I certainly would ask questions along the road.
would you also tell the police after the fact?
Probably, yeah.
Okay. Well, hey.
yeah, that's crazy.
I
Or,
mean, some
you
people,
know,
some people go, "Oh, I don't want to talk until my lawyer's here." But apparently, according to the police, which I overheard them talking, he said some other shit. He was like, "I don't want to deal with the possession charge. I don't care about the evading."
but you think you would tell your lawyer in the sales during the sale rep, and that would be brought up as part of their whatever sale representing.
I
My
wouldn't
client
disagree if
under
there were actually a
duress.
sell rep that took place, but there wasn't.
But also, you would think if somebody get into the car, let's say I am just getting into your car, and I commit a crime, want you to drive. I'm not going to say, drive, please. Hello there. I thought you did taxi cab. Please drive. I would say, drive the fucking car, or you will be stabbed or shot, and I would have the weapon. I wouldn't get into the car and just expect somebody to be driving me because I am saying to drive, please.
I might have to try this.
Just
Next
going to
unlock
get into
car I
people's
see with an
cars and
extra
say,
sign,
drive the
go.
car,
I'm
please.
gonna go drive. See what they do.
Just
Yeah,
drive.
ju-
Thank you.
Just get in and say, "Hey, can you take me to this place?"
That works. I've done that before.
Yeah.
Oh, sorry. It's been done to me before. Not. I don't usually hop in other people's cars. I've done it once, and it was to a public works guy that I knew, and he didn't know it was me right away.
Vance,
That
you
to
know
me
I'm
is
running for
just
Chief Justice.
very crazy.
Did I vote for you for Chief Justice? Of
Did you
course.
know I'm running?
No, I've not caught up with any of the elections except for the two big ones.
Oh. So you've
You
not
guys
caught
do
up
the
with any
small
of the
fry
elections
stuff, you
except
know?
for the third election?
Yeah,
Okay.
I've been focusing on the ones where the fate of our democracy is in the balance.
No, you're right. Chief Justice doesn't matter. It's true.
Well, Chief Justice might have to preside over something regarding the elections, so we'll see.
Are you are you insinuating that the elections are rigged?
No, well, I'm
Are we
suggesting that
stopping
should
the
Jeremy
steal?
win, he's going to appoint two people with vast criminal records.
Okay, there's processes for that.
I understand that, but impeachment would require a presiding, fucking Chief Justice.
True. That could be me, or it could be Winnie. We'll find out at
Could
some
be
point.
Could be that guy. Well, you can't see him, but there's a guy behind you in the photo. Not like physically behind you. There's the wall behind you. It's a bearded fellow.
Buckley?
Who the fuck is Buckley?
He's the guy out front doing the front desk.
No, he's got a portrait up there.
Well, yeah, he used to be a judge.
Oh.
You know how when factory workers retire from factory work, but they still haven't met the age to get Social Security? They take like a Walmart. They take like a Walmart greeter job.
Yeah.
Yeah, it's pretty much Buckley.
That's a good way to do it.
Oh, that is nice. Spooky month. Spooky.
You doing okay today, Vance?
Of course. This took a little longer than I thought it was going to take, honestly. We've been here for, what, 90 minutes almost?
I don't know. I can't see my watch.
You gonna Siri to tell you what time it is being?
I could.
Oh, he's a big apple guy.
He's a senior clerk now.
From
Oh
criminal
no.
capital. Oh,
No, I'm not. I'm not from New York.
oh, all right. All right.
What?
All right. I'm not sure I believe that either.
I'm from Kalamazoo. You know this.
I did not know that. I don't know where that is.
Michigan.
I'm so sorry.
Where the fuck are you from, Vance?
Welcome to Los Santos.
Sorry. God damn it. I was trying this this new thing, and I stopped smoking alongside of it. But now I've had this cigar, and God, I feel alive.
Cursing?
No, I was minimizing my rudeness.
Oh, oh, so cursing was on the table, but rudeness was not.
Yeah, well, I mean, I could say, God, gee golly, you're so fucking nice today.
Gorsh.
I hope you have a wonderful day. And that's not rude. But I say, Jesus Christ, you are the most hideous person I've ever seen. I'm not cursing, but it's very rude.
Is there only two people running for Chief Justice?
As far as I'm aware, Sonny, you running as a write-in?
No interest.
Does it require that you be a what's it called? A judge?
You must be, yes, the cricket judiciary.
Okay, so you wait, what?
You have to be circuit or higher.
Okay, because I was worrying. I was like, what if a fucking clerk wanted to do it? They could just get all the clerk votes if they could sneak enough of them in.
No, we wouldn't allow the clerks to coup.
Yeah, that would suck.
We consolidate power.
I got a decent offer on a car today from somebody. Not a great one, not perfect, not terrible. And I kind of don't want to take it because I'm gonna leave him with a car that he is not gonna be able to sell, and that I know he's not trying to drive.
Yeah, but why do you care?
Because that's fucking evil.
He made the deal, right? He made the offer.
Yeah, the offer, but I still I don't let
So
people make.
do you think he's an idiot?
I think he's unaware. Yes. I don't think just because somebody consented to something does not mean it's good.
So why don't you just tell him it, and then see if he still wants to do it?
Because I'm not sure any amount of pleading with somebody's gonna change their mind always.
Okay.
Plus,
well, if
I
they're-
just put the car up, so I've got time. I can just wait.
If an idiot doesn't want to change their mind, then you take advantage of the idiot.
No. I don't take advantage of people.
I can't
Have you
believe
considered-
actual
Have you tried
love.
it? It's kind of fun.
No, it's bad for your soul.
I don't think that's true.
Ask
Let
Nathan. He
me
has no
see.
soul. He's a ginger.
How would I ask Nathan? He's not here.
He's in the corner over there.
Oh, okay. Windwalker, get over here.
Oh, you must be able to smell him.
Well,
No, I told him he was here.
Vance just said he's in here.
Oh,
Hey, it's about 3 minutes, so you better hurry the fuck up. Hi, I'm Nathan.
Mr. Windwalker, why you woke up so casually? The judiciary called you. You woke with the urgency, sir.
My apologies.
Windwalker, I
God.
have a question for you.
Apology is safety.
I might have an answer.
Okay. If someone gave you a deal that was too good to be true, and you told them, listen, this is a great deal, but you're an idiot for offering me this deal. This is too good for me on my end. And they said, I don't care. No, it doesn't matter. I'm still, my offer is still my offer. Would you take the deal? You get an offer that's too good to be true. You tell them why it's too good to be true, and they stick with the offer. Would you take the deal?
If they're not trying to scam me, yeah.
No. Okay, the offer is bad for them, but good for you, and it actively harms them to take the deal.
But you communicate that, and they
Depends on
still.
what kind of, I guess it depends on like what the deal's for, you know.
Money and cars.
I don't really much have care for money or cars, Vance. I'm not you.
Oh, son of a bitch! It ain't about that.
All
All right,
do
it's
you
fucking
live among the goddamn
candy
trees?
and lollipops. What else? I don't know.
It's potatoes and
Yeah, there you go.
toppings.
Candy, lollipops is candies.
Well, I mean, I can't turn down potatoes.
So if someone made you a great deal, I don't know who your supplier is, but on a shipment of some patatas, and you know they're gonna come out at a loss on this deal, and you tell them, hey man, you're gonna come out at a loss on this deal, but they say, I don't care, I'm sticking to my offer. If you want it, let's do it. Would you still take it?
Yes, and then I tell them get to grow more potatoes because I want another deal.
All right, Vance, there's your answer.
I told you he was a soulless ginger, though. It doesn't mean anything.
Whoa,
His soul can't be damaged.
Vance, either you think this person is too stupid to make their sound decisions for themselves, or you're too scared to take something that's good for you. Those are the only two options here.
It's both.
Okay, if this is some sort of sick puppy that can't be trusted to exist on their own fucking accord.
Well, part of it's also I like the car to go to somebody who is actually interested in driving it.
You're just trying to sell one of your childs?
Yeah.
That explains a whole lot.
Someone
All
offered me
rise.
something.
Court is now back in session.
All right, get the hell out of here.
Forgot to rise. Oopsie.
Anyway. See what happens with this closing.
Apologize, Vance.
I'm sorry. Ignore me.
Respect.
Everyone may be seated. All right, state. Give your opening statements whenever you're ready.
Thank you very much, Your Honor.
Closing, I'm sorry.
Your Honor, as we said at the opening of trial in our opening statement, evading arrest, unlawful possession of a Class 1 firearm. The requirement of evading arrest is the operation of a motor vehicle. In these circumstances, that's being the Gresley Hellhound. While fleeing from a law enforcement officer or Department of Corrections officer, in these circumstances was a law enforcement officer. And as testified by both officers here today, together with the affidavit of Lucas Evans, we know full well that he most certainly did flee in law enforcement. Now, the question was whether he was under detention. Now, Your Honor, counsel would state that essentially that he was, not only him, but everyone in the vehicle were told to stop. Now, the important thing here is, Your Honor, is I don't think there's any ambiguity on the word stop. It's entirely possible. To be frank, Your Honor, in Welsh it means stop here, and that's it. Stop. It's very, very clear. I think it's reasonable to say that he knows what that means. It doesn't mean drive on. It's one of these things, Your Honor. It's very, very clear. Whilst detention may be a question of, we don't entirely know whether he was under detention at the time, it most certainly would have become apparent during the course of the pursuit. In respect of the unlawful possession of a Class 1 firearm, Your Honor, I don't believe that there is anything that needs to be said with regard to that charge. Exhibits produced to the court demonstrates clearly that the firearm was not registered to the defendant, and furthermore, that the defendant was found in the glove box. That's forming a part of the doctrine of constructive possession. Your Honor, in respect of defense counsel's attempt to get a affirmative defense here in the form of coercion or duress, Your Honor, they simply haven't met their burden. Now, that burden is significantly
like that you
lower
can charge
than
4 people
prosecuting
with one gun.
counsel's burden for that is on the balance of probabilities, or as we'd call it in the UK, that's what we call in the UK, the preponderance of evidence in the United States. And simply put, Your Honor, I don't think they've even met 5%, let alone 50%. The requirement for an affirmative defense is that they meet the standard expected. And frankly, Your Honor, we've had more officers testify to the fact that the defendant did not make it clear to officers that he was under duress at any stage. We had a bizarre attempt to wriggle out of the response by the defendant during cross-examination. And then afterwards, we clearly had instances where there was no application of force, Your Honor. There was apparently some concern there may be something behind him. No reason for him to believe that other than the fact that he resides in the States. Personally, Your Honor, I have not encountered such an incident myself. Can't imagine that anyone else has, because in prosecuting counsel's opinion, it cannot be substantiated. Your Honor, this matter seems rather clear-cut to me. I trust it does to the court. The copious amount of evidence produced together with expertly delivered testimony by officers, very, very clean and coherent responses, demonstrates clearly that we have met the standard expected of the offences in question, and we ask that the court come to the only just conclusion in this matter of a guilty verdict. Thank you very much, Your Honor.
Thank you. Defense, whenever you're ready.
Yes, Your Honor. We have one short thing. Your Honor, we'll try to keep it brief. Opposing counsel, people of the gal. We will most likely, formulate on the defense part of it. We do have one small thing to point out. It's the fact that during this trial, prosecuting counsel did not at any point positively identify the defendant. We would point to 2024 CM 347, the state versus Tilly Tumbles, where the Honorable then Magistrate Montana Moss presided over this case and affirmed that
was much different.
all burden,
that was
the burden
so much
of proof
different.
for the crime itself was met. But the defendant itself was not positively identified by law enforcement. The same was done.
I mean, they asked him questions himself about whether or not he was Mirandized.
Objection assumes facts not in evidence. It was demonstrated twice during the examination of officers on direct examination, Your Honor.
Oh my god,
Your Honor,
objecting.
if we may, we have a
in that Tumbles
Sure, I'll allow
case,
one rebuttal.
they had nobody to testify that
Absolutely.
actually had arrested
Officer
her.
stated that it was Connor Westfield. At no point did prosecuting counsel ask on how they came to this conclusion, or the officers actually articulated on how they came
He
to
admitted
this
it!
conclusion. There was a name given and nothing
He
else.
said he drove!
And while the burden
Yes,
of
very
proof
true.
on how to identify a suspect has been gradually reducing in our court, the matter of fact is
Like
that
he
there at
identified
least needs
himself
to be
on the
some
stand.
supplementing
What do you
evidence,
mean?
such as
He
officers
said they
stating
got
that
into my
fingerprints were
car,
taken,
said
MDT records were
drive, and I
compared,
drove.
such and such. Just
So either it's
stating a
perjury
name
or he
at this
admitted it.
point, if this is the grounds we go on to identify people, we might as well close the PDO because there's no point in anyone defending themselves anymore.
This shit. Ooh, I hate that shit.
I don't believe a further response is necessary, Your Honor, but if you believe it necessary, I'll provide.
No, you're fine.
Thank you very much, Your Honor.
Sustain this shit. Sustain it.
I will note the objection in the closing, but just sustain the objection at this time.
Oh, all right.
We'll overrule the
nice.
objection.
Oh, okay. All right,
Which one is it?
So, to continue,
Raph needs his
as we've heard today from testimony, Mr. Westfield, or the driver, was not the getaway driver. He was not involved at all. He felt a credible and genuine threat to his life, which would, under the penal code, justify the charge of kidnapping for the other two suspects that were charged with matters.
What the hell?
It should not require an actual act of force to be acted upon. Otherwise, hostages would be criminal liable as well, because in most cases, hostages don't get shot or stabbed
fuck is
or
happening?
injured, but we still see them as hostages. An act of force is
Did
not
he write
required
this
in
like
this
his
situation.
defendant didn't
Same
go up on the
would be
stand?
here. Both officers
I
only
think
stated
he is trying to
proximity
forget that
and
part.
the fact that the suspect did not state their involvement. On that basis alone, everyone in proximity to a crime is now criminally liable. Every hostage is now criminally liable. Hell, if I drive home after this court case and a criminal jumps in my car and I
Do you
don't
think Ertz
immediately
believes
jump
this?
out, risking the potential threat to my life
I am not
and a
sure.
potential deadly injury and shouting, I am uninvolved, I would also be criminally liable under these standards. The driver did not flee the vehicle after it was stopped. He did not bail out on foot. He remained in the vehicle even while unattended and let himself be arrested. No resistance seen once the believed threat to his life was removed. The defense would assert that people should not wait until they are shot or see a knife at their throat or a gun to their head to comply. Law enforcement may have been on scene, but there was no guarantee for the
defense is
driver that if they
contending that,
resisted the commands of the suspects in the back, that they would leave the
words
scene uninjured.
Are enough
Defense is
to
under the assumption
justify-
that in a situation where
justify a
force
valid
may
threat to
be
your
applied,
life.
it is better to comply with the individual than attempt to
Which
resist and
means,
risk their life, showing no value for their life.
Sonny, if you say
Your
I'm
Honor,
going to kill
to
you, Montana,
summarize,
that means
we
I can
believe
shoot
that
you.
the burden for the affirmative
I'm going to
defense
kill you,
was met
Montana.
today here.
I will find
The
a gun and
driver
shoot
was
you.
not involved. He believed
Oh my
he was
God.
in danger
What
when
is
the
wrong
threat
with
of
you?
force. He purposefully
going
drove
for his
badly
logic.
to keep the chase as short as
I
possible.
believe that
He did not evade after the
all I
threat
can go
was
off of is your
removed,
words to know
complied
that
and
it's a valid
surrendered
threat.
himself without any fuss. So, we have to
It is
show,
crazy.
as counsel outlined, the preponderance of evidence, Your Honor. We would ask you simply, what is more likely? That the driver was a planned, escaped driver, driving purposefully bad and then deciding to just chill in the car and let himself be arrested? Or that the driver was forced to drive under the threat of force, purposefully crashed into things to aid police in apprehending the criminals, complying and surrendering once the threat was removed? We would assert that the second narrative is more likely, Your Honor. As such, we would ask that the defendant be found not guilty on evading arrest, and with that charge being eliminated, we would also argue that the search of his vehicle would be invalidated and be dismissed under the fruit of the poisonous tree doctrine as well. Thank you, Your Honor.
Isn't it okay?
Thank you.
Actual fun legal question here, Sonny.
Okay.
Wouldn't you be able to search this vehicle no matter what? Even if
Yes,
he
it was
under
used in the
duress?
commission of the crime.
Yeah.
To think both parties so much for a beautiful argument, beautiful case. I will take about, we'll say, D, or to give my verdict, but so of course back in recess until then.
All right.
Thank you very much, Your Honor.
Of course.
Who do we call over this time?
I don't know. I could just go over to them.
Right, but is there anyone interesting to
Let
call
me
over?
observe. Only the officers and Mr. Rollin and Mr. Constantino and Mr. Windwalker and the attorney. Could call over Mr. Schneider.
I don't want calling over the attorneys while a case is still
Apologies
yet to
on
be
intrude.
decided.
We have
Hello.
nothing to do with it.
We just wanted to tell you, wanted to say good game, quote unquote. You know.
What the hell is
Yeah.
this?
Yeah.
How the fuck do I know?
What are we good courting?
Well, I'm
good
going off what I'm
arguing?
hearing. What is this goddamn sportsmanship in my
lawyer.
goddamn courtroom?
Yeah, it's
Or wherever.
ESPN. It's ESPN. I
Yeah,
forgot.
What
we're
the
trying to
hell is
keep
it?
good etiquette in the courtroom.
What the hell is this?
It's ESPN.
I think they can hear
Lawyer
you.
Edition.
Well, I know they can hear me because I can hear Ernst because Ernst is.
Do you
Ernst
want
is awfully loud.
bad manners in the court? Should I have said, stinky argument?
I mean, your client could be facing months and months in prison, and you don't know yet. But,
Well, yeah, but if I go afterwards and I say like, "Oh, good game," after I won, that's kind of bad manner. You know,
He did not say Lamau in his
you
closing.
said beforehand. So you're like, we both argued well, and now it's up to justice.
I never did that in my days as an attorney.
So Montana, would you want them to to punch it out or something, or what?
Oh, that would be
No,
interesting.
When I awaited rulings when I was a defense attorney,
Yes,
I
no,
was
very, very
waiting.
well thought out.
I either felt a full sense of relief
Got to say, well done.
wash over me because I knew my
We'll see,
argument
we'll
was as
see,
good as it
we'll
was going to get, or I felt like there was the power of 1,000 suns weighing on my shoulders because I didn't know how it was going to go, and I felt like maybe I failed this person.
How does it make you feel right now?
I don't feel anything right now. I've got a cigar for the first time in a week. This is wonderful.
How does that cigar make you feel?
Like $1 million, Rick. Like $1 million. And according to Vance, you'd spend that $1 million all on cheeseburgers at the Cluck and Bell.
The fuck? No, you told Montana I spent $1 million at Cluck and Bell?
Nobody.
No, he said Montana said that. Montana said you said that.
You see what these
Who's lying, Montana?
this
Is it Montana or
nicotine-
Vance lying?
He called you fat earlier. I used that to make a joke because I'm funny.
Oh, sorry.
That is funny.
Thank you, Sonny.
Someone could get contempt.
Oh my goodness. I am online
Yeah,
shopping.
that Ernst closing really was. Who knows who did this? This heinous act. It couldn't have been my client who said he drove on the stand.
This could not be. Not
Yeah.
him.
Sonny, do you think I have some unnatural gift to get my cases to go to trial?
It's a speeder.
Mm,
Because I feel like I've had a very good record of it.
you did?
Maybe
What'd you say?
you didn't find
I
the
say
right
you
people.
did?
Well, no, I don't have an actual record, but I think I've had a ton
no,
of these
get to
things
Maybe
go to-
court.
12 p.m.
Yeah,
That must
feel
be
like I'm always in a courtroom.
nice for you.
it's wonderful.
Mm. I am very unhappy. I
Why
just
is
want to
that?
go to court. It's not fair.
Just impose your will on people and make them do hearings when
There.
you get annoyed at them talking on the docket.
I finally get the case again,
My
and then
email's
you
coming
say, "Oh,
to you.
already taken care of." Haha. Mm.
Sorry, Sonny. Do you want Emily Snow, the case that I ruled there's no probable cause for her DNA to be collected, but no one's motioned for it to be
There you
dismissed yet?
go.
No,
Okay.
I don't want to touch that shit with nothing.
Okay. I might wait a couple days, but then I'm gonna throw out a scheduler for it and just see what happens.
very confused,
Maybe
aren't
then
you?
somebody will motion for a dismissal. If not, we'll just go to
Hans is
trial
very confused.
with no DNA, which will be fair.
Oh. Mm, Continue. Oh my god. Let me order my grocery. Fucking bitches. Ah.
So who you voting for?
533185. I have not determined yet.
Okay. When
I have
does,
notes to compare.
When do when's voting even end? Or do you know? I don't know. I put my
The
vote in right
15th?
away. 15th?
Yeah.
Okay. So we got about a week till we find out. That's fun. I don't think I'm gonna win. And that's fine. I think Raj has kind of groomed Winnie to be the next Chief Justice for a while. And I think Winnie would be good even if she did win. But I think I can bring something new and unique to the table that I don't think Winnie offers.
Hmm.
Can you at least tell me this, Sonny? Are you like one of
Oh.
those like super feminists that were just because Winnie would be the first woman Chief Justice in the state, you have to vote for her no matter what?
No, I don't think so.
Oh, okay. All right, easy enough. Vance, get over here. Windwalker 2.
Come on, Ginger.
Hmm. I need that. I want
Okay, bye.
that.
I had to clarify with that
I
other
don't
guy
need
that it was
that.
not him.
I
Tom.
need
It was another
that.
Ginger in the audience.
Shit, I am sorry.
I have a question for each of you. If you were a gun, what type of gun would you be?
Combat pistol,
Okay, why?
because I own one. I will also be a ceramic if that's better.
Why would that be better?
I just think it's cool.
Okay. See what I mean, Sonny? The way they answer it tells a lot about them. Windwalker, what about you?
We're talking pistols or handguns, rifles.
I, the
Oh my
question
god,
is
you don't know anything about illegal
question,
guns.
The question is the question, Windwalker. If you were a gun, what type of gun would you be?
Squirt gun.
Ha ha.
Is he good with the ladies or something? Why do you say that?
Just non-threatening. I don't know.
I would have to be
Fun at parties.
probably the MK2 mock revolver, like the big gun.
You just like the big gun? Any other reason?
No, it takes care of what it needs to do, with one shot typically. Pow. A lot of power.
Okay. See, Sonny, we're learning about people with this. I'm gonna start using this more widespread.
Oh, very interesting. I have a question.
Yeah.
For who?
What is the best excuse you ever successfully use it to get out of a traffic citation or maybe a restable offense?
Oh, I was under duress.
Did you admit to it on the stand and then have your lawyers say, "Who? Nobody ID'd this man.
Well,
Nobody knows who did this."
to be fair,
Yeah, how
to
do you put
him,
him on the stand and then he's
that's
testifying
what I
about
said.
everything
Yes.
that happened and they say, they never identify him though.
Well, I think he did raise a good point at that there was no evidence. I don't think it was even photographic evidence of him being there.
Well, they arrested him on the
I
scene.
understand that, but you know,
Is
Yes,
the
there's
testimony
photographic
that
how do they
this is the
identify
person
that man as
insufficient?
him?
Vance, I have a question. Do you want every police officer in every arrest, in every traffic ticket, to have to pull out a camera and take a photo of the
No,
person
no, no.
they
What I'm
are
saying
detaining?
is when they got back to the station, they didn't state how they identified him. I'm assuming it was just fingerprint, right? They must have been on record.
It's typically a part of procedure.
Yeah, but it was never, you know. Normally you hear prints are mentioned or something identified via fingerprint. They did it to fucking me. Actually, they didn't do it to me because I had no prior record.
So the case law he brought up was one where nobody that actually arrested the person testified, and also there's just a lot of missing testimony in that case. That the case law he brought up was a shit show case.
I remember.
Those are good ones.
Yeah, it was a terrible case. That was awful.
It was one DOJ fumbled.
Yeah, because they had the arresting officer in the gallery, but never called him as a witness.
Oh, I think I remember that one. I don't remember what it was, but I think I remember hearing about it.
It was interesting.
It was dumb. And I don't like people trying to use dumb things as case law. Windwalker, do you know I'm running for Chief Justice?
I do. I'm the one tallying all the votes.
Oh, nice. How am I doing?
I don't think I can disclose that till all the votes are in. So.
Well, here's the question: How
Good.
many are
Yeah,
we almost
yeah,
all the votes in
don't-
yet, or no?
No, there's still 2 more to be done.
Oh, I didn't think you'd tell us the number. Cool.
Wait, there's only 2?
2
2
left.
left.
Out of the whole
Who is
judiciary?
left besides me?
I don't know the name.
Out of the whole like clerks and all, everyone got their votes in already.
According to Tommy.
All right, hey, we're
I
good at
thought
this.
you were counting this. What's going on?
I am counting them. He's just told me who hasn't voted yet.
Yeah, that's different jobs. He's counting 1 for Montana Moss, 1 for Winifred Baker. Tommy's Xing out names as they vote.
Yep.
I'm going to wait
Also-
till the last minute for the voting. Haha.
Also documented every little bit of voting, like who voted for what when they voted. So if anyone questions the vote, we've got the receipts.
Well, now I kind of want to question the vote just to find out who voted for who.
It's nice to see another PDO other than Ernst.
Oh,
Poggers.
is there another PDO here?
There's
Rachel.
some lady, Rachel.
Rachel, one that was hired the same time I was, Montana.
Oh, she had a bad answer for probable cause about a week ago.
It's all right.
She is just getting
Good
back
start.
into things,
Oh.
so
Right, but she has a bar card.
So it's not my fault. Who gave it to her?
I'm not trying to be a smartass here, Montana, but I am. Can't
Humpy.
see it, but I'm shrugging right now.
Okay.
Humphy did it.
I don't know, man. I miss Humpy.
I'm on a. You know, I care so much about probable cause that then, ironically, a handful of days ago, it was thrown in my face.
Haha.
Why?
Because a few days ago, I'm sitting on a bench in Legion Square, being returned there after I was taken hostage so someone could refuel their car for a chase. And I'm doing warrants.
That is crazy.
Smart.
Did you inform them you were a judge?
No.
You should.
I don't like
Mr.
dying.
Moss would not wish to abuse his power to unduly influence something of that nature.
Yeah, I don't
But
like dying.
plot armor.
A lot of people at Avalon tell people, hey, we're gonna law firm, and they go, oh my god, and they usually let us go.
Anyway,
Yeah,
I'm
somebody
gonna
tried to kidnap me the other day, and
Oh
I
my
was with
God.
Lady Becker, and they put us in the cars. At first,
Who the
they
fuck
not
is
even
Lady
pointed no
Becker?
weapons. I say, Lady Becker, they not have no
Baker.
weapons. I say, no, thank you. And then they pointed the gun. I told them I was very busy. They asked me many questions. They said, what are you doing? I said, I am working. They said, what are you working on? He said, you are nosy. And then they tell me to get in the car, and then they asking Lady Becker her name, and then they bringing us back.
Bedtime.
What was that?
What was Rick? Who the fuck is Lady Becker?
Baker.
Winnie.
Oh, Baker.
I'm old.
Fuck me, I'm so
What is so funny?
I thought you said Pecker, and then you said Becker, and then it turns out it was Baker.
Yes, why would I say Lady
Yeah, but I'm
Becker?
old.
It's Lady
Are
Becker.
you
I
deaf
don't
or
know.
dumb?
I think he is both.
No, some ladies got peckers.
Okay, sure.
That is not for me to debate.
33.
I will not be touching that one.
No, there will be no touching in this courtroom.
What do you think of my outfit? How cute is he being?
It looks good. Nathan's fallen rather ill.
What do you mean he falling ill?
Is he dying?
He
Is he running for office?
Yeah, it's tragic.
How many people running for the office? It's crazy.
Shockingly, the same amount of people are running for both positions. So 4 governor, 4
37.
what was it, legislators?
Oh. But Defendi seeming very confident. He over there just sitting with his friend.
Okay. Okay,
Yeah,
I
didn't know
wonder.
he was allowed to get up.
Here is my question: why the state or defense not call it the female passenger of the car?
Well, the state probably didn't want to do it because she'll just lie.
No, not in the crisis.
But
that is
Also,
fair.
yeah, no, they didn't find out the affirmative defense could subpoena her ahead of time anyway.
Why do I need her? Why does my back
So
hurt?
quick.
Yeah,
All
Rick, I
right,
think it's all the
we're
extra
back
weight
in
on
session.
your knees and back.
Oh no!
Oh my goodness! You should be
I am
rising
about
and going
say
to your
something,
seat.
But I don't want to get condemned.
You sitting here?
No
You mind if I
balls.
take that?
Everybody a little bit of time to get back to their seats.
Tell him no balls.
Y'all may be seated.
No balls doesn't work on me.
Respectful of the courtroom etiquette.
Mhm.
All right.
Court finds the facts of the case. We'll start with the facts of the case. Mr. Westfield drove the vehicle away from officers despite being told
All right, so it's a guilty.
not to leave. That part's a little bit up to interpretation. He evaded law enforcement, but what's not disputed is that he evaded law enforcement for 10 minutes. Crashed the vehicle multiple times. During the pursuit, the vehicle eventually claimed to a stop, and he did not resist in any way, shape, or form, and a firearm was found in the glove box, not registered to anyone in the vehicle. The defense is. We'll start with the address of the defense as one of the defense's.
I would
arguments that
also
was
ask if
brought
he was
up
just going for a ride
during
with his
his
lady
closing,
friend.
whether
Why is he
defendant was
stopped at
positively
that
identified
location?
today. That point is actually made mute by Mr. Westfield taking the stand on himself and confirming under oath that he was at the scene behind the vehicle and participated in the pursuit, even stating that he was
Look at that.
trying to crash.
Ref caught
was
it.
a
Ref
bad
caught
driver. His own
the easy
testimony
layup.
removes any reasonable doubt about his identification. As for the claim of duress,
Yeah, that
the
is
court
fair.
finds no credible evidence that Mr. Westfield
Oh, he
that
guilty
no one
of all.
threatened him. No weapon was shown, no force was given. He only said he felt pressured, which does not meet the legal standard for distress. He never told officers that he was afraid or being coerced. Not even when in the safety of the holding cells did he try to seek help or explain the situation after being detained. So accordingly, the grounds of affirmative defense of concern or duress has not really been met. Both officers, Diaz and Gray, testified that all occupants were told not to leave. That Mr. Westfield chose to flee, driving recklessly, endangering others, and endangering others. Their testimony matches the physical evidence, including the firearm, and a mere lack of resistance of arrest doesn't really prove duress, especially the defendant's actions, fleeing, and again, not
I wouldn't be
seemingly duress,
resisting. I would
show
be
the
running to
deliberate
the
choice.
safety of the
Taken together,
officers.
record Mr. Russell's actions on his own free will knowingly ignored law enforcement and later tried to excuse his actions with claims of fear. Based on this evidence and omissions of Mr. Westfield is found guilty of evading arrest and one count of unlawful possession of a Class 1 firearm.
CTC recommendations.
Did you just sneak the guilty in there?
Yeah.
Okay.
Do you have any sentencing recommendations?
Yes, Your Honour. Counsel would motion for
Frivolous.
frivolous defence in these proceedings.
Oh, yes,
and
please.
Of course, we ask for the statutory maximum for a start, being 55 months and a $550 fine. However, we make our motion for
God,
frivolous
please.
defence to double this, to increase it to the sum of 110 months and an $1,100 fine, Your
And
Honour.
this is why you don't say good game to the other lawyer, because they could come around and do this to you.
All right.
It should have been happening either way.
Your
They
Honor, we
should have
would
assumed
object
it.
to frivolous defense. For the benefit of the court and for the benefit of opposing counsel, the idea of raising an affirmative defense was not brought forward by Mr. Westfield. It was an idea brought forward by myself, as I believe I
What?
would be the
Oh
best
my
approach
God.
for this matter, as
What?
otherwise we would have had no defense at all.
Oh my
what?
God,
As
what?
it stands right now,
What?
I do not
Is
believe
this
it
a
would be
sabotage
fair to
plate?
penalize my
What?
client for
What the hell?
recommendations I have put forward. He could have obviously said no, but in how it stands right now, we do want people to, trust in what their lawyers say. He did put the trust in me, and
That
he
you
did
you
fail
sue your
today.
lawyer for
He
this.
did raise a defense, though.
You
can
sue your
argue
lawyer.
Wait,
for as long
I
as you
have a
want that this
question.
may have not been a good defense.
If
But
if
this
it
was
is
not
his
something
idea
that
for
was
the
put forward
affirmative
or,
defense,
demanded by Mr. Westfield.
because no
personally.
defense otherwise, what?
We would ask for the standard
Does that
time
mean
and
he was
fine,
committing
though.
perjury?
Yes, that is my
Is that what
question.
you're saying? Yeah. We're on the same
In
page.
Your Honour's own ruling, there was no credible evidence presented that there was a belief in there being any kind of application of violence, the apprehension of violence, or anything of the sort, or any evidence that would suggest that he would be entitled to have such feelings of duress asserted to the court. And therefore, we say that the defence fails on that basis. Well, the affirmative defence. Furthermore, the defence stated that this was their
I
only
am
Hail
very
Mary. So
concerned
where that
here.
fails, surely the entire defence, therefore, is frivolous, Your Honour.
Defense, I'll allow one more
There's
rebuttal.
no defense otherwise.
One moment.
I wish Raph catches on this, because I don't think it's our. I mean, is it our place? It's probably not our place to do anything about that. Maybe recommend it as a Sabbath complaint for
Your Honor,
Ernst.
we would argue at the end of the day, frivolous defense, as it is defined by the Supreme Court ruling of 2023 AC 066, is the determination that the court's time and resources has been wasted. We would assert today that the defense has made, in genuine good faith belief of defending Mr. Westfield, we would all agree, we would assert that no resources were wasted here today, and as such, the matter of frivolous defense would not apply. We would also assert that frivolous defense should be treated as a high burden. Otherwise, every time a defense fails, the prosecution can just ask for frivolous defense, which is not how this.
I would say that it is pretty
Mr.
frivolous
Westfield
to say I advise him affirmative defense.
As some of the
Otherwise, there
suspects
is no
do,
defense
with
at
the
all.
express intent to
What-
just waste resources. He did, in fact, want to just make his, face his accusers as is his rights, and also have his ability to defend himself at trial, which he did.
Perhaps they did not say anything about being under duress because there was
may,
no
Your Honor?
duress. It did be manifest by Mr.
Less
Slater
response is not necessary. Thank you
in
very much,
order
Your
to
Honor.
articulate the affirmative defense.
Your Honour, we would argue that, yes, indeed, he is entitled to face his accuser in court. However, as Councillor Schneider put it, it is a question of whether they have wasted court resources. In these circumstances, Your Honour, prosecuting counsel would state that where a defence is completely fails, by your honour's own words, the defence was nothing was asserted that would even remotely come close to it. Nothing in the prosecution's
I'll be honest,
case
the biggest
was
argument
brought
for
into
frivolous
genuine
here
question,
is
and because of that, there's
the
absolutely no
argument in
defence available
closing
the
being
circumstances. And
so
the defence
clearly
therefore is entirely frivolous in
already
nature,
proven within the
per the
case.
requirements of the case law stated by Councillor Schneider.
Yes,
That
they didn't
concludes
identify
our
my
remarks, Your Honour.
client
Thank you very
despite the
much for your
fact that he got on the
consideration
stand and
for
asserted
allowing us to
to
make any further
participate in
rebuttal.
everything except under duress.
That is my closing argument. Please believe me.
One moment, please.
Oh, he thinking.
So I think he's gonna do it. I think he's gonna do it. If I know Raph and I know him fairly well, I think he dips the toe here. I think he dips the toe into being a hard ass judge, Raph Massey.
Do you think he's going to do that? First solo case.
I think he's gonna do it.
It's a very high bar set for frivolous defense, and
but
I do not take that even close to lightly.
He's gonna do it.
I have a hard time believing that someone would not, in good faith,
Should we be speaking with
bring
Mr.
arguments for us
Schneider following this proceeding?
after that.
Is it inappropriate to ask him?
There's a lot, but in this,
I think it's a fair
case,
question if he encouraged his
due
client to perjure
the
himself.
sheer lack of evidence or anything brought forth against what the prosecution brought forth.
If his client perjured himself at all,
we will allow frivolous defense.
Oh, wait, he granted it.
Could you please state the time and fine again for the record?
Oh my god,
yes,
he
Your
did
Honour.
grant it.
The
you are right.
The frivolous
I know,
defense,
Raph.
the total time is 110 months and an $1,100 fine. This representing 30 months for the offence of evading, together with a $300 fine, and then afterwards for the Class 1 possession, this would be 25 months and a $250 fine, totaling 55 months and a $550 fine, doubled to 110 months and a $1,100 fine, Your Honour.
That's a lot of time for such a little fine. Don't you agree? 110 with $1,100.
Conor Westfield, you are sentenced to 110 months and a fine of $1,100.
Raph's just soft spoken, but he's got some teeth.
We conclude today.
Oh, I like him.
Nothing from the prosecution, Your Honour.
Nothing from the defense.
Thank you.
Bang that gavel.
I
Thank you very
almost
much, Your
painted
Honour.
mine.
All right. Wow. What a twist.
Yeah, that was interesting. I would like to.
Hello.
Hey,
Oh, hello there.
Hello.
how you feeling?
Bad.
Why are
Why?
you feeling bad?
Sophie, it looks like I'm getting taken. I'll see you
I
later.
gave them frivolous defense. I don't want to give them for
Okay, be
defense,
safe.
but it was pretty bad.
Well, I mean, their entire closing statement, he said, you didn't identify my client that I put on the stand.
Yeah,
And he
I know.
clearly articulated participation in
There
the
when I was
entirety
last
of the
week.
event.
Yes.
I do have some serious questions, though. He said, not frivolous defense. This was my idea to take the affirmative defense. Otherwise, we have no defense at all. So my question is, was there ever the belief of any duress, threat, coercion? Or is this something that Ernst advised the client to be asserting?
Basically, did Ernst advise his client to perjure himself?
Yeah, that's what I was thinking a little bit about that too at the end. I don't said that he came up with the idea. Again, that's not he came up with it yesterday. That means he Yeah, that's not good.
Like, I am of these concerns. Either, I mean, it makes sense if you're not saying anything about the rest in the cells. You don't say anything about the rest to the officers. Nothing until they late filing in the docket. Uh, I I am concerned.
I mean, do we want to ask him? Is he still in here?
Is it here?
Ernst, whenever you get free, you mind popping over here?
Yeah, one moment. You.
I think it's a genuinely fair question to ask.
I do too, actually.
How when
Because
did
because if his client wanted to defend the case and he didn't feel he's under duress, but he just felt hard done by, that's he still got up on the stand and said he was under duress, or not, whatever words.
I'll do my best. Hello.
Okay.
Hello there.
What you had said in the argument against frivolous raised a question to me and for all of us, really. So, did your client actually feel he was under duress?
He did.
Okay. The reason why we're concerned is you said you raised this idea for the argument as the affirmative defense because there's nothing else. And it got into our heads that if you raise this idea and your client obviously wanted to fight this at trial, but we were concerned that perhaps, Ernst, that you raised, hey, your best way out of here is if you say you were under duress.
No, I had asked him of what the situation, like, you know the outreach email we sent at PDO.
Yeah.
It was the, like, explain your story. He was like, oh, you know, 2 people jumped in my car. I felt threat. And I was like, well, the best possible way, the best chance we had to move forward is to basically argue that as an affirmative defense.
Okay.
So why did you only indicate this affirmative defense like 24 hours ago? Is that when your client finally responding and providing this
Pretty
information?
much, yeah. I reached out to him like a week prior to please tell me who the passenger was, so we may also be able to call them as a witness. And then I got a response like a day ago, pretty much.
Okay. Okay. Listen, I don't know about these two, but I believe you, Ernst. We heard what you said, and we were concerned that you were like, hey, man, you're only shot out of here is if you say you're under duress.
Yeah,
because then he went up there and said it on the stand.
Yeah, no, I understand the concern, but I'm not Saul Goodman or anything. I'm not trying to cheat the courts here.
All right, good, perfect.
I was entertained. Very interesting court proceeding.
I do appreciate that.
And Mr. Misty popped into this jury today. Oh my god, beautiful.
First solo trial.
Yeah, for first trial, I actually pretty much I guess I did one with you, but I wasn't really in charge of that. So
no, that was kind of me with you just learning. Basically, I was the tree of knowledge, and you were a squirrel climbing up my branches and munching on the leaves.
You know, squirrels munch on leaves? I thought they not munch on nuts.
I don't know. I haven't seen a squirrel or anything in 6 months.
That's fair.
Oh, why did the squirrel swim on his back?
Why?
He don't want to get his nose wet.
That's good.
I heard a joke last night at the place. Anyways.
Anyway, while we're here, do you mind doing a background checkaroo for me?
Sure. Do they know what probable cause is?
I am not sure. They were former PDO, so I would hope so.
Oh, is this the I think this guy called me.
Rex Novak.
Yeah, Rex Novak. How the hell do you spell any of this?
Rex as in like T-Rex, and then Novak as in like the Officer Evan Novak. I don't know if they're related. And like November Oscar.
There it is. I found it.
Because
Hold
I
on.
would be perfectly honest with you, I forgot what V was in the
Hold on.
military.
He was involved. There's one
Violin.
incident.
V is for
There's-
violin. Or
Oh,
van.
he's a victim. Okay. I for a second I thought he might have been involved in a bank robbery, but no, he was a victim.
Okay, well that's
So that's the only incident on his record.
okay. Awesome. So yeah, he called me there at the end, and I was like, oh yeah, no, totally forgot, because he submitted that like last week, and I told him like, yeah, I'll get on that. I just forgot over the whole.
Yeah, he had called me, and then I got blood ritual by Junie Peters, and then she called the police.
What?
She's done the blood ritual to previously, and then I reported to those police who were blood ritual previously that I got blood ritualed, and I wanted to report it as a crime. And then the police took our statements. Then apparently the DOJ said there's no probable cause there, so they cut Junie Peters loose. And then a few minutes after that, Junie Peters comes back around and points a gun at me. Well, she said she wanted a gun at me. Who's to say? And says, "Get in the car," and then takes me to 2 locations and stabs me. So, and then I yelled at the DOJ. So I didn't think much of Rex Novak after he called me.
That's fair. Yeah. Okay. Well, that's everything. I'm gonna go to bed now. It's way too fucking late. I have no clue why I agreed to be starting this late. I must have been either incredibly sleep deprived or high, but it is what it is. I'm glad you were able to do your first actual case round.
Thank you.
Mr. Missy getting more case than me to the card.
Well, you know,
just need better luck.
Yeah, sadly, can't. Sadly, we just have. Sometimes we just have shit clients. It just hasn't.
Way it goes. What was that?
I am tired, and I am not looking forward to tomorrow.
Oh, what is tomorrow?
Tomorrow's
the other
Roxy night,
case,
and
Roxy.
yeah, that's Winnie's case now.
I know.
Oh.
I guess I could have offered it to you, Sonny, but you weren't there when I was offering it to people for freely.
Darn. I will try to attend.
It is. When is it?
I have no idea.
I think
It's
at
like-
7
I think it
p.m.
was
for
like
whatever
7.
reason I am feeling.
Yeah, 7. No, it is 7 p.m. I just checked.
I just look at the calendar.
Yeah, that's what I do.
It is written on my wall here.
It is again really late, and I again don't know why I agreed to it to be that late, but you know, it is what it is.
You should sleep in, relax it tomorrow.
That's what I'm. Well, given the current time, that is most certainly what I'm going to be doing. So
You could just quit your job.
I could, but I'm also not a quitter.
Me neither. One day I will get to the court.
It's
Maybe
also
I
like
will resign and go back to the prostitution, or to be
May-
the defense attorney.
it is definitely also a matter of like, I guess like personal. I don't know, it's not exactly pride, but personally, I'm not someone who just kind of like goes like, yeah, now I'm done, bye, and then just leaves everyone else hanging. I'm not. You know me, Montana. I'm not a person like that. Raph does as well.
You know,
Oh.
Mr. Moss, knowing Ruff very good. He say, Mr. Missy will is approve the frivolous defense. He call it that.
He did call that.
I mean, it is like it was like we don't have to discuss. I just have to. I can't just be like, yes, Your Honor, we don't have any objections to frivolous defense. Like that's just gonna get called into Rafa's office again and be like, you have to at least mount some defense. You know, like he did on the weird lady who claimed that her freaking the driver who was the actual criminal got kidnapped by aliens and then wanted me to argue that in court.
Ha 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 ha. Did I miss this court proceeding? What happened?
It was a bench trial, so probably. I forgot who was presiding over it. I think it was Montana, actually.
Oh my goodness.
I don't remember this.
Did you find the
I
alien
don't know.
abduction
I don't know if
case
it was you.
guilty?
Yeah, no, she was found guilty.
Oh, unfortunate. I would say that is affirmative defense. You must be proving the aliens are existing
Mm-hmm. Pretty much.
and that the abduction did be occurring.
Yeah, that's gonna be a difficult one. We just have to prove that it's more likely than not that they exist and it had happened. So, like, I don't know. You take pictures of some crop circles or something and be like, pyramid aliens, more likely. Yeah.
Oh my god. I am sorry to have missed that one, huh?
Yeah, it was a bit exhausting because for me it was just like no objection, no question, no nothing. It was just just said no to every, and then that was my, I think one of my, like, it wasn't like one of my first bench trials.
Oh my
but it was
god,
like the
I
first
could get
time
the
where
cheap
I'd learned was just
viewers.
like say no if you don't want to do bench trials. Just say no. Yeah. All right, coolio. I'll see you all.
Yeah,
I guess tomorrow maybe if you dare the trial for Roxy.
Yes, I will try to attend.
I will
If
not be there.
probably like
'cause
around the weekend or something.
If I could be there, I would have been there, but I can't be there,
Mhm.
and therefore I won't be there.
That checks out. All right. Well, you all stay safe. I'll make my way out.
East of this sunny day.
Do you think the door's gonna be open?
No.
I think I know somebody that can be open it.
I can snag it.
Yeah, Raph can do that.
Awesome. Thank you very much.
Yes,
All right,
goodbye.
so he didn't violate anything. It was just the only thing potentially.
Oh. Interesting.
Easy enough. So how do you feel, Raph?
I feel overall I did good. I mean, a little shaky at times, but I kind of saw it coming. But overall,
Was you
I think I
using
did
my
good.
strategy I tell you?
I did.
What was the strategy?
When they are making the objection, allow the rebuttals so that you can take the time not to listen to the other rebuttals, but to determine your ruling on the objection.
Oh yeah, that is smart.
That is why I love the rebuttal. By all means, yes, please do. All right, I too am going to go to sleep. Thank you for Oh, I got a French Canadian grappa. I'm eating the girl dinner.
Congratulations.
I feel so girly.
Raph, do you need anything from my wide branches of knowledge from this learning tree?
Actually, I do.
Oh, okay. Hold on.
You weren't expecting that.
Okay.
Actually, about my civil case.
You have a civil case?
Yeah. The
Is it the
defendant-
small fucking claims one?
Just a small claims one. I don't actually know how to ask for like bank records and stuff. I've never done that before. Because they didn't pay. I've never done any of that.
Are you asking how to serve the subpoena, or are you asking like how that work? Like, what are you asking me?
Both? I guess how would I ask for it?
It is sort of difficult to explain. Something like the banking records would be, you are familiar with the manner in which the sentencing for the capital charges is handled?
Yeah.
It will be
That.
similar to that,
Alright. Okay.
but different location, not in there, not that
Okay.
email. You would have to open the separate new email.
Yeah, just make sure you have a just like a record of your order to whatever. You can't just do these things willy nilly, you know. Just
Yeah. Gotcha.
have a record of your court order to do so, and when you do that thing, reference that.
All right. I can do that. All right. Totally. Thank you.
What else you got for me?
We have our we have our Amir case, which is ours now. Anything on that I did wrong was other than forgetting. Well, it's kind of mute now about the bell thing, but other than forgetting the bell when I wrote my big old ruling.
I'll be honest, I haven't looked at it.
That's perfect.
All I've seen is that Celeste refuses to CC anybody.
Yeah.
Which is driving me insane. But beyond that, I haven't seen anything. Have you done anything important?
The motion for discovery, but Celeste pretty much answered all the questions. I basically just like, I consider this all satisfied.
Okay.
That's pretty much it. And then they asked for Bell, but I don't understand why they asked for Bell.
They probably just want new conditions.
Probably. Doesn't matter now.
What do you mean it doesn't matter now?
They already broke. Oh, they broke their bell.
Oh, well, that's not good. Was it just bail, or I thought I saw something about PC hearing?
It's also PC hearing, which I'll schedule that. Just send me your times, and I'll try to get one where you can be there. But yeah, I'll probably schedule that either Monday or Tuesday, maybe even.
Okay, fair warning. I signed this warrant. So I probably want to abstain from ruling on like, I know we generally don't care if people preside on the same stuff they sign a warrant for. I personally don't like ruling on my own warrant.
Yeah, I don't mind doing it by myself.
Like, I guess I can be there, and if you have questions for me, you can have questions for me. But Sonny, I don't know how you feel about this kind of thing, but I don't like ruling on my own warrants.
It would be ideal to avoid if possible. However, I don't see, because here is the thing: the probable cause hearing based on the warrant, if the defense is bringing up the points that perhaps you overlook it and not consider, can consider to reconsider. You have to compartmentalize and listen to the arguments.
Sure.
And then rule it based on the arguments.
But yeah, I can get you my availabilities. Basically, the answer is what's someone else's availability so far? Jesus Christ, what the hell is Celeste's availability? This is terrible.
2 p.m. to 6 p.m. on Saturday, 2
9
p.m. to 6
p.m.
p.m.
to
on Sunday.
2 a.m. What the hell?
Oh my god.
Basically, Sunday evening, and then after that, any other day, pretty much after standard work hours, EST.
All right.
The only exception to that this coming week will probably be Thursday. But
why is the officer indicate the availabilities?
I think they just misunderstood.
No, I am misunderstood.
Yeah, I'll send it over officially, but that's generally how they are. Cool. Anything else you need from me? Do you want me to review everything and let you know if you fucked up at all?
I always like knowing if I fucked up, so if you want to, go ahead.
All right, I'll take a look and at some point before we have the PC hearing, and if I see anything that you really fucked up on that isn't just interpretation, I'll tell you.
All right.
I do have a question, Mr. Macy.
Of course.
Your signature on this docket, look very interesting to me.
Yeah, my text to speech reads a lot of error 404 bullshit, and I don't know what that means. Is that some sort of new hip slang you're doing as your signature?
Yeah, really trying to stay hip with the times.
I see.
We'll try to.
Also, I enjoy the copy sent to copy sent to.
Okay.
That is okay. I posted a ruling or decision earlier today, and in doing so, I copied the entirety of the docket and post. Don't worry, I edit silly. Whoopsie. That was oops. But now I am going to go to bed. Good luck to all of you. Enjoy your cases. I don't need any court. No court cases for
Do you
me.
have any other questions about Chief Justice?
No, I just said that I wanted to ask more questions after so that you would be quiet so I could attend to the court.
Oh, okay. All right, fine. You know what? You're right. Oh, shut up.
No, I just wanted to hear the card. Is there anything you wish to add to your platform?
That I am going to be the same exact person that I am now.
With or without the smoking?
I'll be honest, this feels wonderful, so probably with.
Okay, perfect. Let me read this down. Wonderful. Okay, I'm going to go to sleep. I'm going to contemplate on this decision this evening, and I will submit the vote tomorrow. Have this sunny day.
All right, wonderful.
I like to do the market research. Is there anybody to be ready? Hello, anybody ready? Anybody here? I need to go to sleep. Roxas, we going to read the Roxas, raccoon lady. I have to go to the fall festival tomorrow. I don't know what I'm going to do there. I'm going to see some pumpkins and go shopping. Thank you for hanging out. Thank you. For make the heart happy, have the both average night and this sunny day. Court entertaining, as always. Interesting arguments. Some arguments more interesting than others. Anyway, bye.